This one? There we go. So good morning, everyone. It's truly an honor to be here. As a new member of the commission, I just want everyone to know the Commission of Ethics doesn't believe in hazing unless your name is Glenn Gilzine. So, but other than that, it's an honor, it's a privilege, and I'm looking forward to working with this great group.
Thank you. And with that, we'll stand for the Pledge of Allegiance to be led by Mr. Gilson.
See, I told you.
It's an honor and a privilege.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next, we have consideration of the July 26, 2019 public session meetings. And before I have a motion, there is a change I'd like to make. At the top of page 3, Jared Reddick, complaint 18-111. I actually voted no and confirmed that with staff. So I'd like to make that change. Are there any other changes to the minutes? With that, may I have a motion?
Motion as amended.
I have a second. A motion and a second to approve the minutes. All in favor signify by saying aye.
Aye.
Any opposed? Minutes pass. I have a few preliminary announcements. The First District Court of Appeals lets us use their facilities, so please respect their rules and have absolutely no food or beverage other than water in this room. Please silence your cell phones. Anyone addressing the commission, please speak up so our recording equipment can pick you up properly. And my fellow commission members, please be sure to speak up into the microphone so those watching this on our live stream can hear you. Members, we have a considerable agenda at this time, so I'll ask you please that be as brief and concise as possible in your questions and comments. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases which we act in a quasi-judicial capacity. That means the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up. Where is she? Right there. I'm used to you being in the back. All right, we have had a request by Attorney Timothy Quayles. He had an injury this morning, and he would like to go first with 5B. In re Catherine Drew, complaint number 17-064. Will the parties and their counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Good morning, if I may address you from back here. My name is Tim Qualls. This is my client, Catherine Drew. We're here to answer any questions. Thank you.
We have before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or to reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have not received any such comment. The advocate will present the stipulation.
This is the case where a respondent, while employed with the Nassau County School District, conducted business with the district. Respondent violated sections 112.313.3 and 7. In the stipulation, the respondent admits she violated the ethics law and agrees to the entry of a final order recommending a civil penalty of $2,000. We respectfully ask for the commission's approval of the joint stipulation.
Are there any questions from the commission?
Move to approve the stipulation as presented by the advocate.
Well, first I'd ask the respondent have any comments?
Oh, thank you.
All right, motion by Commissioner Brady. Do I have a second?
Second.
Second by Commissioner Lesnoff. Any discussion? All in favor of approve of the stipulation signify by saying aye. Aye. Any opposed? Say nay. The stipulation carries. Thank you. Next, we are going to go to 5C, only because this is a little bit different than the other ones. This is a consideration of final action pre-probable cause stipulation. This is on complaint number 18-128, Adam Pollock. Will the parties and counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Good morning, Commissioners. I'm Ron Meyer. I'm here on behalf of Mr. Pollock, the respondent.
Thank you. We have before us a proposed pre-probable cause stipulation between the commission advocate and the respondent. After considering all the matters and the presentation of the parties, the commission may vote to approve or to reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, we will go immediately into the probable cause determination. Complainants have the right to comment in writing on proposed stipulations. We have not received any comments. The advocate will present.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to disclose a partnership on his original 2017 CE Form 6. We ask the commission to accept the respondent's stipulation that he violated the ethics code and recommend imposition of a civil penalty of $250.
Mr. Meyer, do you have any comments?
No, we just urge the favorable treatment.
Are there any questions from the members? Do we have a motion to adopt the stipulation?
Move to.
Motion by Commissioner Berger,
Second.
second by Commissioner Brady. Is there any discussion on the stipulation? I just have one comment, and I start to sound like a broken record. I have seen a number of these in my almost 4 years on the commission, and this is a very low amount. We've had others that are similar that have been in the recommended penalties that have been passed at a much higher rate. Yes, Commissioner, our advocate.
And I can address that. For me, when I do pre-probable causes, when there's one issue, Mercasell Powell, she had 2 issues. It was $500 on a pre-probable cause. On Catherine Van Zant, again, $250 when it's a pre-probable cause and it's 1-2 issue. That's how I generally have been doing them. So Catherine Van Zant, Charles Van Zant, and Debbie Mercasell Powell have been similar to this.
All right, thank you.
Sorry to interrupt.
Thank you. Do I have a motion on the stipulation? Oh, we already have a motion. I'm sorry. So a motion by Commissioner Berger, second by Commissioner Brady. Any other discussion? All in favor of the stipulation signify by saying aye. Aye. All opposed? Nay. And I say nay. Thank you.
Thank you.
Thank you. Now we'll go back to item 4A.
Excuse me, Madam Chair.
Yes, sir.
You said something where, you said in the past that you said it was low. I wasn't here in the past. Could you just expound on that for me, please?
Sure. If you look at your agenda, there is a list of recommended penalties that we've done that have been recommended by the commission since the beginning of the commission's time. And I particularly know of 2 matters from my own county, Brevard County, where there were 2 financial disclosure issues, and they agreed to pay $1,750. And again, I mean, the financial disclosure is the meat of what we do here, and I just think there should be more respect for those forms. So that's why I think $250 is very low for violating.
So just one quick follow-up, and then we'll continue with the agenda. So what, out of curiosity, what would you feel is because I can't ask you this outside of this meeting, right?
Correct.
Because that would violate sunshine. So what would you feel is a fair amount going forward?
I just think there needs to be consistency, and I actually think about $750 for each violation would be appropriate. But that's just me,
Yeah.
based upon what I've seen in 4 years.
Okay.
Thank you. Okay, we are back to item 4A, Henry Matt Shirk, number 15-002R. Will the parties or their counsel please identify themselves for the record?
Elizabeth Miller, advocate for the commission.
And there's no respondent present?
Correct.
All right. Okay. We have before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have not received any such comments. The advocate will present the stipulation.
Thank you. Commissioners, this is the second time I'm before you with a joint stipulation. The first one was rejected by the commission. In this current stipulation, the respondent admits to 2 violations of a misuse of office, and he admits to a violation that he disclosed information that he obtained in his official capacity that was not otherwise available to the general public. He admits to the facts in the report of investigation. He admits that those facts equate to violations of these 2 statutes. The fine that we ask for is $6,000 in total with a public censure and reprimand, and we respectfully ask that this joint stipulation be adopted.
Are there any questions from the commission? Do I have a motion?
Move to approve the joint stipulation as requested by the advocate.
Second? Do I have a second?
I'll second.
Motion by Commissioner Brady, second by Commissioner Lesnoff. Any further discussion on the motion? Yes, Commissioner Meggs?
I wouldn't want to cross Ms. Miller. It just seems to me like when I looked at that case, and I was familiar with it from earlier, before I became on the Government Commission, it seems to me, I don't know if that's a maximum fine, but in my opinion, it would be easiest to get the maximum.
Yes, sir, the maximum fine, if I may,
Yes, please.
is $10,000 per violation. So maximum, of course, would be $30,000.
Commissioner Meggs, could you expand on that?
Well, I just thought his conduct in office was real egregious, the way he did things and the way things happened over there. And I was familiar with it when it was going on a little bit, and so it just struck me that he violated a lot of things that just public official ought not to do. But I'll vote for the motion.
Any other
Just
comment?
don't like it.
Any other comments? Yes, Commissioner Berger?
I would comment along the similar lines of Commissioner Meggs in that this is pretty egregious facts. I agree that there absolutely needs to be a public censure and reprimand, which you have. The issue of the Florida bar is really a non-issue for us in that the Florida bar, I have confidence in the Florida bar that they will do what they need to do, what's appropriate to do, but I echo what Commissioner Meggs said, which is this is a kind of case with very strong, egregious facts that screams for a louder punishment in regards to the fine. I will go along with this. I believe this case has been around since 2015, and this is the second time back, but from my standpoint, I would prefer a much higher fine.
Any other comments? All in favor of the stipulation signify by saying aye.
Aye.
Any opposed? Nay? I vote nay.
Thank you, Commissioners.
Thank you. Next on the agenda is 4D, Henry Robert Lang, complaint number 18-134. Will the parties or their counsel please identify themselves in court?
Elizabeth Miller, advocate for the Commission.
There's no respondent present or counsel. We have again before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have not received any such comments. The advocate will present the stipulation.
Thank you. Commissioners, the respondent is the current finance director for the town of Fort Myers Beach, and he has entered into a stipulation with me whereby he admits that he failed to file a CE Form 1 within 30 days of being hired to that position. He admits to the allegations and agrees to pay a civil penalty of $750. We ask that you adopt the stipulation.
Are there any questions from the commission of the advocate? Yes.
When
Commissioner
did he
Brady.
file the disclosure?
He filed the disclosure when the complaint was filed, and he went to his general counsel for the city of Fort Myers and Fort Myers Beach, and was told then to file it. So he filed when the complaint was filed.
Yes.
The
Commissioner
reason he
Brady.
didn't file was, didn't know he had to?
Correct.
Okay.
Any other questions? Thank you.
Thank you.
Ms. Miller. Do I hear a motion on this matter?
Move to adopt the joint stipulation.
Do I have a second?
Second.
Motion by Commissioner Lesnoff, second by Commissioner Berger. Any further comment on this? All in favor signify by saying aye. Aye. Any opposition, please say nay. Motion passes. Next, we have Henry Bruce Greenlee, complaint number 18-1870. Will the parties or their counsel please identify themselves?
Melody Hadley, Commission Advocate.
Thank you. No respondent?
No.
We have before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard at the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. We have not received any such comment. The advocate will present the stipulation.
Respondent served as the Director of Transportation for the Levy County School Board. This is the case where respondent misused his position by exhibiting inappropriate behavior toward a member of his staff. Respondent has previously attempted to stipulate to this at $2,500. The commission rejected that stipulation. And this stipulation, respondent again agrees to a public censure and reprimand and increases the penalty up to $4,000. I respectfully ask for the commission's approval of the joint stipulation.
Thank you. Any questions of the advocate? Thank you, Ms. Hadley. Are there any, do I have a motion?
I'll move to approve the stipulation as presented by the advocate.
Do I have a second?
Second.
Motion by Commissioner Brady, second by Commissioner Berger. Is there any discussion on the motion? Yes, Commissioner Mills.
In this particular one too, seems like we dealt with this at some point in time,
Just the last meeting.
and there was, I don't know, it seems like there was
There was a letter by the complainant.
some untruths told. Anyway, I thought his conduct was real egregious, and I thought he took the easy way out by resigning as mayor. He was mayor of Bronson, he was also an employee of the school system. I just think the fine is low. I will vote for the motion, but I would think he ought to get hit a little harder.
Any other discussion on the motion?
We've rejected this once, right?
Last time at $2,500.
He's the one who chased the woman around the office. Yeah, okay. I mean, I would throw my motion if you feel that it should require be refined.
I can live with it, I just,
Yeah, no, I understand what you're saying.
Can I ask you, what we rejected did not have a public censure?
Either, did it? No.
Yes, yes.
It did have public
It did.
censure reprimand. It was just at $2,500. And the complainant in that case, at that time, issued a letter somewhat stating or indicating that she was upset with the amount. She has not sent a new letter. As a matter of fact, I have spoken with her, and she, as an officer of the court, she was fine with the fine amount.
Thank you. Do you want to withdraw your motion?
No, I
Okay.
gotta leave it, I'll leave it, okay.
Any further discussion? All in favor of the motion to approve the stipulation, please signify by saying aye.
Aye.
Any opposed, please say nay. Motion passes. Next, we move to item 5, consideration of advisory opinions. We have 5 advisory opinions on our agenda today. File 2740 will be presented by Gray Schaefer. Is the requester here? No. Mr. Schaefer.
Thank you, Chair. Commissioners, I originally presented this meeting to you all at your July meeting. It concerns a municipal police chief who wondered if he could act as an unpaid officer of a local nonprofit. And in particular, wondered if he could engage in fundraising for the nonprofit. And he said the nonprofit intends to do 2 things with the money. First, to make charitable contributions to needy families and individuals in the community. And second, use donations to purchase gear and equipment that it will donate to the police department. Now, you asked me to redraft the opinion in July for several reasons. And I've tried to address each of your concerns in the redraft, and I just want to review with you the changes that I made based on your feedback. First, a concern was expressed as to whether the donations to the nonprofit could be considered indirect gifts to the chief if they're used to purchase additional equipment and gear for the police department. You wanted me to spend a little bit more time thinking about that particular issue. That's covered in questions 1 and 2 of the redrafted opinion, which go over the concept of an indirect gift. As the draft explains, an indirect gift is one in which the chief ultimately receives the benefit and is intended to receive the benefit, even if the gift isn't given directly to him. So as you can see in question 1, my advice is if the nonprofit accepts contributions and uses them to make donations to needy families and individuals in the community, I don't think those donations can be considered indirect gifts to the police chief because he won't be experiencing the benefit of any of those donations. They're going to be going to the needy. But as question 2 explains, if the donations are given to the nonprofit with the intention they be used to purchase equipment and gear for the police department, it's then arguable the donations could be considered an indirect gift to the police chief if he uses the donated equipment or gear, because in that case, he'll be personally benefiting from the initial donations. So question 2 of the opinion advises him he should treat donations made to the nonprofit to purchase gear and equipment to be donated to the police department as indirect gifts if he intends to use them, and he should respond in accordance with the requirements of the gift law. Now, what the gift law says regarding the chief is that he's going to be prohibited from accepting a gift of over $100, whether given to him directly or indirectly, if it's coming from a prohibited source. And that would be a vendor of the police department or a lobbyist or a principal lobbyist of the police department. So if a prohibited source like a department vendor or lobbyist contributes more than $100 of donations for the purpose of the nonprofit purchasing gear and equipment to be given to the police department, I think the chief has 2 choices. Choice number 1 would be not to use the equipment or gear once it's donated, because in that manner he won't be experiencing the benefit of any of the gifts. Choice number 2, if he wants to use the gear and equipment, is to figure out if a prohibited source contributed more than $100 in donations to purchase the equipment or gear he wants to use. If that's the case, he's going to have to reimburse the original donor for any amount they contributed more than $100. Now, the gift law goes on to state that if a donor is a non-prohibited source, just some general individual in the community, the chief can accept any gifts from that individual, but he's going to have to report them if they're more than $100. So the opinion advises him that if you have a donor to the nonprofit who is not a department vendor or lobbyist, and they contribute more than $100 to purchase a piece of gear and equipment, and he wants to use that piece of gear or equipment, he's going to have to report the initial donation as an indirect gift on a Form 9 if it was more than $100. Now, this does place a large burden on the police chief if he wants to use that gear and equipment, but I believe if he follows the advice in the redrafted opinion, he will be in compliance with the gift law. Your second concern, which I think Commissioner Lesnoff expressed, was that the general goodwill he could engender in the community based on his affiliation with the nonprofit could in itself be considered a gift. If the nonprofit is making donations to the needy and donate equipment and gear to the police department, and it's well known that he's affiliated with a nonprofit, the issue is whether the bolstering of his reputation in the community could in itself be considered a gift. Now, I've looked at that issue again, but as I explained in footnote 8 of the redraft, I do believe something more is needed to trigger the gift law than just a general feeling of goodwill or the general bolstering of his reputation. Our statutes define the term gift as a thing with an attributable value. So it seems that general goodwill or the effect on your reputation is just not enough under our authority to be considered a gift, because there's no real attributable value, no tangible value can attach to it. The third concern that you all express is in question 3, which is whether the chief can solicit donations on behalf of the nonprofit while wearing his uniform or mentioning his title. You were concerned that even if he receives permission from the city to do so, and even if wearing his uniform or mentioning his title doesn't violate any local prohibitions, the people might feel coerced into making a donation if he's asking for it while wearing his uniform. I put some cautionary language at the end of question 3, emphasizing he should be very careful if he wears his uniform or mentions his title during fundraising to make sure the donations aren't being given out of a sense of intimidation. But I still feel, based on prior commission opinions discussed in the redraft, that wearing his uniform or mentioning his title without more are not going to be enough to find a misuse violation under our misuse statute. That statute is just triggered if someone is acting in a manner inconsistent with the proper performance of his duties. He's indicated that he will obtain proper permission to wear his uniform and mention his title, and our draft warns him he shouldn't be doing so if it's going to violate any local ordinances. but provided he receives permission and stays in accord with local regulations and ordinances, I don't think we can say then that it's going to be inconsistent with the proper performance of his duties to do so. So I understand the concern, but my recommendation is that it is not enough under the advice we're giving him to constitute a misuse violation. Your last concern was that I make sure to address each question raised in the requester's email. I do think this draft addresses all those questions, and I put language in a footnote clarifying that. And I haven't heard from the requester that they're unhappy or feel that the draft is incomplete in some way in terms of what they asked us to address. So I offer the opinion now for your review, and I'm happy to answer your questions.
Commissioner Berger?
Just wanted to make a disclosure. I serve on 2 nonprofit boards that have police chiefs and sheriffs. I'm president of the St. Lucie County 100 Club, and I'm the secretary of the Port St. Lucie Police Foundation. This no relation to the city of Cocoa Beach, and I don't view it as a conflict for me to follow the advice and legal advice and legal analysis and legal recommendation, but I did want to disclose that.
Thank you, Commissioner Berger. Any other questions? Yes, Commissioner Brady.
Just to make sure I understand, he can accept a gift over $100 because it's an indirect gift?
He can, no, what I'm saying is that if the gift is given from a non-prohibited source and it's going to the nonprofit, and it's going to be used to purchase gear and equipment that he wants to use, according to the gift law, he can accept it, but I just think he'll have to disclose the fact that a donation of more than $100 was given to purchase that piece of gear or equipment.
Okay.
Any other questions? Commissioner Leslie?
Yeah, and I think perhaps I miscommunicated my concern last time. My concern is that it's not how he'll be perceived generally, it's how he'll be perceived in his job by his workers and by those who put him in his position. And my concern is his ability to seek solicitation from those he does business with. And I know you caution in the opinion that he can't do that with the expectation of a favor. However, I believe when someone is contracting with an agency, there is going to be a continued relationship. There is going to be that time when someone needs something from that other person. So I'm very concerned about that. I also think I reviewed the relevant laws and found a couple of things that I think are in conflict because I don't think the statute contemplated that it allows donation to a government entity, but I don't think it contemplated that the government entity would be the same government entity from which they were getting a solicitation. Because the law also says that someone cannot receive a benefit from that solicitation. And so in the extreme, if the police chief would contact each person with whom he has a large contract and says, will you give a car, a new patrol car? And as a result, the police now has a new fleet of cars. Certainly that, he's benefiting from that. He doesn't have to ask the commission for money. He doesn't have to deal with repairs. There's obvious benefits to the police agency having a bunch of new cars. So I think that that's the conflict, and I understand the basis by which you wrote the opinion. I can understand that perspective, but I can't support it only because I believe the statute didn't contemplate this specific set of circumstances, and I believe we'd be setting forth a precedent that probably was not intended.
Commissioner Lesnoff, is there a particular question that your concern is addressed to, or is it the entire opinion?
It's really about the accepting donations from soliciting and accepting donations to the department. So it's not the uniform, it's not the other charitable organizations, it's simply calling your vendor and saying, give my agency this thing. Would you give this agency, my agency, whatever he's looking for?
If I
Yes.
can respond to that, Chair, I understand your concern, Commissioner. If you look at footnote 10 of the opinion, it deals with, and I didn't talk about this in my presentation just because this is a complex opinion. I was trying to boil it down to its essence for you all. But the solicitation statute in the gift law is section 112.3148 subsection 3. And it's, when it comes to solicitations, what it does is it prohibits the chief from soliciting a gift of any amount from a prohibited source, which would be a vendor, a lobbyist, or principal lobbyist of the department, if it's intended to be used to benefit himself, an immediate family member, or another reporting individual. I don't believe that it can be triggered then if he's soliciting a gift on behalf of the nonprofit, as long as he doesn't intend to use the fruit of that donation, meaning the equipment or gear that is ultimately going to be donated. And I do understand your concern that his affiliation with the nonprofit is going to be enough then to be considered a benefit, because he's going to be strengthening the police department if equipment and gear are given to it. But again, I think that that goes more to how he's perceived amongst his officers and amongst the community, his reputation, if you will. And that's just not a thing with an attributable value that we've ever treated as a gift in the past. I do think that if he's engaging in those solicitations and he's going to be asking for donations from prohibited sources, he should not be using the equipment or gear that is then donated to the department. One other thing I will point out is that the opinion, I think in question 1, gives him some advice about the bribery statutes, that he should be very careful no matter what, whether he's engaging in solicitation from a prohibited source or non-prohibited source, to not create any impression that he's going to be taking some public action in return, either immediately or down the road, in exchange for those donations. We do warn him about that, but I just thought it was going a little bit too far if we presume that every donation given is with a quid pro quo like that. But I do understand what you're saying, Commissioner.
Commissioner Brady?
Yeah, just to make sure I understand, so hypothetically, because it goes to a third party and then to the police department, it's not as big an issue if he solicited himself to go directly to the police department?
I think that in that case, the question would be, is the gift coming directly to him? Is he going to be experiencing the benefit of any of it personally? And my take on the situation is he's just going to be benefiting if he's actually using the equipment or gear that is donated to the department.
I mean, but if he went to a car dealership and said, we have this nonprofit, and it's a general nonprofit in the community, and it does all kinds of good things, and in the middle of its charter is something that says it can give gifts to local law enforcement, and if you give a gift to this foundation, you'll get a tax deduction because it's an appropriately certified 501c3, and then they can turn around and give the police department the car. It's not considered to be a prohibited source because it goes through a third party?
It would be coming from a prohibited source then, as long as the source is a vendor or lobbyist of the police department, but it won't be considered an indirect gift to him unless he's actually using the gift. And if I can draw a parallel, earlier this year, you issued an opinion, which is mentioned in this redraft, to a member of the Broward County School Board, and she was an officer. She and her husband, I believe, were the only officers of a local nonprofit that was set up after the Parkland shooting. She was the mother of one of the students who was killed. And what she asked us was whether or not she could solicit donations, maybe from even vendors or lobbyists of her school district, but the money was just going to be used by the nonprofit to be given to the school to conduct training on school violence for students at the school. I think in that case, you found that because she wasn't accepting a salary from the nonprofit, so there was no way that the money was going to end up in her wallet. And number two, the ultimate fruit of those donations were not going to really give her any tangible benefit. You found that that was not in itself a prohibited indirect gift. And I think that's the parallel here. You know, as long as he is not personally using the gear or equipment that the donations are being used to purchase, I don't believe it can be said that he's receiving an indirect gift then from the outside donors.
Any other questions? Do I have a motion?
I'll move to approve the opinion as presented.
Is there a second?
I'll second.
I have one discussion point. I am not comfortable with the language at the end of question 3. We caution the chief not to use the weight of his uniform or title to intimidate or coerce constituents into donating. I don't think the chief would ever do that. I think the caution would be to remind him that the weight of his uniform could impress upon people to donate. So I would ask that we either strike that or change it to that the weight of his uniform may intimidate despite any lack of intent to do so. I just thought it was patronizing. I just don't like that language.
What page on your?
I'm on page 12, just before where it says, however, 3 is answered accordingly, question 3. I just didn't like that sentence.
Okay.
And so that would need to amend your motion if you want to take that out or change it. I just didn't think it was commentary. I thought it was directed to the motion.
So what would you like some?
I think it should be, however, we caution the chief that the weight of his uniform may intimidate, the weight of his uniform or title may intimidate despite any lack of his intent to do so. Or something along those lines. I just thought I just didn't like that language. Or we could take it out entirely.
Some language that said something to the effect of, we caution chief to understand that the weight of his uniform and title may intimidate or coerce constituents into donating would be fine, as long as it seems to say, we want you to be aware of this, we don't think you engage in this behavior.
Right. That was my only concern, and this is my district, so this is my.
Can we approve the document with leaving the wordsmith in to the discretion of the staff?
Yes.
Through the chair, that is done from time to time, Commissioner, that if Mr. Schaefer is clear on the wording change, then the commission can adopt the opinion with the wording change, and it will be rendered without having to come back at another meeting.
I'll maintain mine.
You'll accept that amendment?
Sure.
Okay. All right, so now we have before us file 2740, motioned by Commissioner Brady, seconded by Commissioner Meggs, with the amendment agreed to as to that one sentence in question 3. Is there any further discussion? Mr. Anderson.
Through the chair, Mr. Schaefer, are you clear about the language change?
Yes, I am.
Seeing no further discussion, all in favor of acceptance of this advisory opinion signify by saying aye.
Aye.
Aye. Any opposed signify by saying nay.
Nay.
Commissioner Lesnoff voting no, the advisory opinion is adopted. Next, we go to file, 2741, which will be presented by Carolyn Klenke.
Good morning, Commissioners. Caroline Klenke, Commission staff. File number 2741 comes before you as a result of an inquiry from Amy Toman, Deputy City Attorney for the City of Tallahassee. Her inquiry poses 4 hypothetical scenarios which are addressed in the 3 questions for your consideration today. Each question involves city public officials and members of the city's leadership team accepting complimentary tickets from public and private donors, and which involve events in which the city has an interest. In all of the scenarios, the elected and appointed public officials and employees on the city's leadership team file financial disclosure and thus have the additional gifts restrictions which Gray Schaefer just discussed and which are set forth in section 112.3148. As we just discussed, these additional gifts restrictions fall into 2 primary categories. As you know, section 112.3148 applies only to those individuals who file financial disclosure. Subsection 3 of this provision provides that reporting individuals are prohibited from soliciting gifts from prohibited donors such as lobbyists, the principal partner firm or employer of lobbyists, or vendors of that individual's agency. I will be referring to these individuals as prohibited donors for the purposes of this analysis. In addition, under section 112.3148 subsection 4. These reporting individuals are also prohibited from accepting gifts having a value that exceeds $100 from these types of prohibited donors. Alternatively, however, we must also address the transparency requirements involved in gifts that are not from prohibited donors. And in particular, in subsection 8, it provides that reporting individuals may accept gifts of any value from non-prohibited donors, i.e. non-lobbyists of their agencies and non-vendors of their agencies, but they must report them quarterly on a Form 9 if the value of those gifts exceeds $100. As a result of this bifurcated regulatory scheme set forth in section 112.3148, the identity of the donors is of paramount import in every gifts analysis under 112.3148 and in all three of the questions for your consideration today. In question 1, the city inquires whether complimentary tickets to events held by nonprofit and for-profit entities and given to city officials and city employees on the leadership team are gifts, and if so, how those tickets should be valued. Scenario 1 is further complicated by the fact that in this fact pattern, the city itself, in association with this event and as a predicate to receipt of the tickets, has paid for a sponsorship benefits package, and commensurate with the level of that sponsorship benefits package has received, pursuant to that payment, an array of benefits, which may include advertising and name recognition for the city during the event, blocks of free tickets, both to the event itself and to VIP activities transpiring during the event, and event swag or event trinkets. Following the receipt of the benefits package, the city manager then offers the complimentary tickets to the city's elected and appointed city officials and to members of the leadership team on a first-come, first-served basis. First, the opinion in question 1 provides that the complimentary tickets are gifts as they are encompassed within the definition of gifts set forth in 112.312.12a. As these tickets constitute gifts, the opinion then goes on to discern the identity of the donor. Are they a prohibited donor or are they not? In question 1, the city has provided equal or greater consideration for the benefits package in the form of the sponsorship payment, and thereafter received the benefits, which include the complimentary tickets, which include the tickets that they've paid for, which they then provide for free to the city public officers and reporting individuals on a first-come, first-served basis. Thus, the opinion in question 1 further finds that the donor in question 1 is the city itself. Therefore, it goes on to analyze that because neither the city nor the city manager is encompassed within the definition of a prohibited donor, the city is a permissible donor, and the city officials are free to accept the tickets, even if their value exceeds the value of $100. However, under section 112.3148, the opinion concludes in question 1 that if the value of the tickets exceeds $100, they would need to be reported on a Form 9. And with respect to that valuation, it provides that the valuation criteria of section 112.3148 subsection 7 and Commission Rule 34-15.500 on the valuation of gifts is germane to that analysis. It provides guidance that when a ticket reflects a face value, the value of the ticket is the face value times the number of tickets received by that reporting individual. If, however, the ticket reflects no face value, in inquiries and responses to requests for additional information, it became apparent that often in such scenarios, other members of the public would be able to obtain or purchase tickets to those types of events, even where no dollar value is reflected, And in such a scenario, the ticket cost would be the comparable value to persons with similar tickets multiplied by the number of tickets. In question 2, the city seeks further guidance as to whether tickets or admissions to VIP events or to early performances, which are not otherwise available to the public and given to city officials who file financial disclosure free of charge, are gifts, and if so, how those are valued. In this scenario, the city is the primary organizer of the event, and the general events are free to the public. However, the inquiry focuses upon tickets to VIP activities transpiring during those events, which are not available for free to the public, but rather are ticketed and have a limited access. These tickets, however, are either provided by the city itself as the host. However, for these events, there are other sponsors, both public and private in nature, who may be the originator of the tickets in question. Following the receipt of the tickets, though, the city manager, whether he receives them from the city or from one of the other sponsors, either a public or private entity, offers them free of charge to these individuals who file financial disclosure on the city's leadership team and public officials. Therefore, of primary import in this scenario, once again, is the identity of the donor. And thus, in question 2, the analysis requires that the individual donee, the gift recipient, must discern the identity of the donor. Are they a prohibited donor, or are they a permissible donor? And for the reasons that were described in question 1, if the donor of the tickets to such VIP events is the city itself, the opinion provides that the tickets are from a permissible donor and thus may be accepted, even if their value exceeds $100. However, they would need to be reported pursuant to section 112.3148 if the value of the number of tickets received exceeds, by any particular reporting individual, exceeds the value of $100. Conversely, however, the opinion goes on to opine that if the donor of the tickets is a third-party sponsor of the VIP event or performance, and they have provided the tickets to the city manager, the donee must discern if that third-party donor is a lobbyist or the principal partner firm employer of a lobbyist or a vendor of the city, i.e. a prohibited donor, and specifies that if the donor of the tickets, of the indirect gift in the form of tickets, is a third party that falls into that category, if the value of the tickets exceeds $100, they cannot be accepted under and pursuant to section 112.3148, subsection 4. If, however, the third-party donor of the tickets is not a prohibited donor, i.e. is not the principal partner firm employer of a lobbyist or a vendor of the city, then the tickets similarly may be accepted, but have to be reported quarterly on a Form 9 if the value thereof exceeds the value of $100. In question 3, the city asks whether complimentary tickets to fundraising events held by nonprofit entities that receive annual funding from the city and which are given to elected and appointed city officials, as well as members of the leadership team, are gifts. In this scenario, the opinion concludes that the tickets are indirect gifts from the respective nonprofit to the city official. As such, the respective donee must discern if that particular nonprofit donor is a prohibited donor, and if so, provides that if the value of the tickets exceeds $100, those tickets cannot be accepted. However, if the donee recipient discerns and identifies that the nonprofit is not a prohibited donor, i.e. not a lobbyist, the principal partner firm or employer of a lobbyist or a vendor, then it falls into the category of permissible gifts under 112.3148, subsection 8. The tickets may be accepted by those individuals. However, if they have a value that exceeds $100, they would need to be reported quarterly on a Form 9. Staff is available to answer any questions you might have.
Commissioner Brady?
If you don't file disclosure, then there's no requirement. If you're not a reporting individual, then there's no requirement.
That's correct. You have, when you do not file financial disclosure, you have the gifts restrictions that are contained in section 112.3132 and 3134, which prohibit the category of unauthorized compensation or bribes, which is separate and distinct from that of gifts.
So a private nonprofit, that a government entity gives money to provide services to residents of the city is not a vendor?
It could be. These are hypothetical scenarios, and in question 3, therein lies the reason why the analysis is bifurcated in and of itself, in that it provides guidance on how to traverse and navigate these waters, and provides that there is onus and burden in these types of scenarios, wherein the gift recipient must discern, is this person a vendor? Are they, for example, as you see from the definition of vendor, a representative of a business entity that does business directly with the city, either selling goods or services to that agency? And if they are, then they fall into the prohibited category of subsection 4. But if they are not, then they could, and there is feasibly an instance where a nonprofit that receives annual funding may not be a vendor and might not be a lobbyist. Therein lies the reason why the final footnotes in your analysis define, once again, lobbyist, because it is broad. And so they should be cognizant of that broad breadth in the definition as they scrutinize this analysis.
Any other questions? Is the requester present? Would you like to comment? All right, do I have a motion on the adoption of this draft opinion? Oh, don't all speak at once.
Yeah, I'll move to adopt the gift disclosure, though I do find it incredibly uncomplicated, and I think it does really provide hypothetically way more discretion than I think you intend to do. Primarily because it becomes so obfuscated in the who does what to who, and who reports and who doesn't, and what the relationship between the giver and the receiver is, that if it's, as the receiver of the gift, it's my job to really conclude that the gift comes from an appropriate source, and short of somebody having significantly more knowledge than I have, nobody's ever going to know. And I mean, I don't know how much of that is implicit in the law itself. And you get kind of a sense when we talk about the nonprofits, you get that. I mean, if I'm Lawrence Kids, my founder is a state senator. My founder's father, who I believe is on the board of Lawrence Kids, is considered one of the 3 or 4 most powerful lobbyists in the state. My guess is they give tickets to lots of people to events, and my guess people don't really think twice about it. And I mean, I think that's kind of, the roles get very, very muted. And I understand it, that makes more sense the second time I read it than the first, but I think it's a very complicated kind of a statute that's more complicated by the opinion.
Do I have a second to adopt this draft opinion?
I'll second.
Motion by Commissioner Brady, second by Commissioner Lesnoff. Is there any further discussion? All in favor of the draft opinion? Oh, excuse me, Commissioner Meggs.
You know, as I read it, as I listened, I get about as confused as a termite and a yo-yo. It just seems to me like that probably what we ought to do is say, don't take things unless you pay for them if you're a public official or a reporting person. But thank you for the opinion. took something. I don't know that I would make a Form 9 report if somebody gave me a ticket to something. I don't know, it's just very confusing. And I don't know that the opinion clears it up. I'm sure you know what to do now.
We haven't adopted it yet, Commissioner Meggs.
I
Is there any-
think we probably go tell people, don't do this anymore. But anyway, I think I understand what you said. I am a little confused by that.
Commissioner Berger?
Yeah, I just wanted to add to what Commissioner May said. What I'm looking at, which is legal analysis versus better practice, and I agree with Commissioner Meggs about better practice. If we're voting as to the legal analysis, I think you've articulated it well, and if we're following the law and the legal analysis, I get it, but I couldn't agree more about better practice is not to do it.
Any further comment?
Just
Commissioner
from a process standpoint, if we chose to postpone this, what happens if this motion dies? What's the next step?
Mr. Anderson?
Yes, thank you. Well, the commission has various options here. There could be another motion to either continue the opinion or ask for some changes in it, or there could be a motion to outright reject it. That's kind of rare. There are different things the commission could do, but certainly if there's not an affirmative vote to pass the opinion as drafted, then that won't become the opinion. Now, if I could go a little bit further, if I might.
Sure, Mr. Anderson.
That one of the reasons the opinion is complicated is because the legislature in 1990, when they enacted this gift law on the heels of some criminal gift prosecutions that Mr. Meggs obviously was involved in at the time, the legislature was sort of coaxed, let's say, for a mild term into doing something about gifts. And so, and this is not the current legislature, this is many years ago. And they enacted this law, and it just, you could put somebody in the electric chair under the needle with a lot less language in the statute than you have in this law. But when they wrote it, the intent, I think, was to allow the party in Tallahassee to be kept going in a lot of ways. And originally, like, you could eat all the food and drink you wanted at one sitting, and it wasn't even defined as a gift. And then through the years, that got amended. But there are so many policy provisions that are in the particular points of this law that anytime you write an opinion about it or you ask a question about it, it necessarily has to be very detailed and very legal like this. And I think this is a completely sound legal analysis of the law. Now, we do, over the phone often, tell people, look, this is what the law says on things, but do you really want to appear in the newspaper tomorrow as having taken these things? So there's a lot of best practices advice that comes out of our office. Technically, the commission does have the ability to continue an opinion request, but in this case, I think it's just been thorough in both the communication between the requester and Ms. Clanky and discussions with myself, and I feel like it is right for issuance, and it doesn't seem to me that there would be any point in delaying it. Of course, that's the will of the commission, but I think it is a sound legal answer, but behind that always are best practices that people often do beyond what the law requires.
Any further questions, comments, discussion?
Yeah, Madam Chair, I think I would like to make an amendment to the motion if we could just delay it, because I do need a little bit more time to stew on it, go forward. And if it's not, if my amendment fails, I guess I would have to vote no on this.
All right, Commissioner Brady, would you like to withdraw your motion?
Sure, as a courtesy to the newest member of the commission, I'll withdraw the motion, allow him more time to think through the opinion, though I do tend to agree with our attorneys that it's probably our member attorneys as well as our staff attorneys, that it probably is the best drafted thing from a rather conflicted and confusing law.
Commissioner Lesno, you all right with withdrawing it?
Oh, yes.
All right, Mr. Gilzean, would you like to make a motion to continue this to the next meeting?
Madam Chair, I'd like to make a motion to continue this to the next meeting.
Is there a second?
I'll second it.
Okay, Commissioner Brady, is there any discussion on the motion? Yes, Commissioner Berger.
I just wanted to add, when we're going to revisit it, because what we've heard is there's pretty clear legal analysis on that, but the practicalities are a little different, that maybe there's some addition of cautionary language
Yeah.
that addresses the
Yeah.
practicalities in readdressing
agree.
this opinion.
Yes, I agree with that wholeheartedly.
All in favor of the motion to table to the next meeting, signify by saying aye.
Aye.
Any opposed, signify by saying nay. Passes unanimously. Thank you, Ms. Klenke, that was very well done. Next, we have file 2744, which will be presented by Deanna Roming.
That'll work. Thank you, Madam Chair. Commissioners, this opinion concerns City Housing and Community Development Division, hereinafter referred to as the Division, employees participating in the city's Community Redevelopment Agency Purchase Assistant Program, hereinafter referred to as the program. The request was brought by 2 employees of the division who would like to know whether a prohibited conflict of interest would be created by their participation in the Home Buyer Assistance Program, where the program hired their agency to review and process prospective home buyers' applications. Relevant to this inquiry is Section 112.313, subsection 7A of the Code of Ethics. The first part prohibits the employees from having a contractual relationship with the CRA, an agency arguably doing business with their division, with their agency, the division. The second part prohibits the employees from having a contractual relationship, which would create a continuing or frequently recurring conflict between their private interest and the performance of their public duties, or which would impede the full and faithful discharge of their public duties. The employees here meet all the income and household requirements to participate in the CRA program and have already made the 3% down payment to secure their respective homes. Although currently secured, these employees will not be able to afford to complete the purchase of their homes without the program subsidy. As presented in the draft, in addition to the CRA arguably doing business with their agency, a contractual relationship appears to exist between the employees and the CRA, the agency that administers the program subsidy. However, in their public capacities, the 2 employees do not personally work for the CRA or with the program that reviews the home buyers' applications in the division. As such, they are not in decision-making positions related to the CRA, including the CRA program subsidy. Nonetheless, if it were to be applied in isolation, the draft explains that the employees would be restricted by Section 112.3137A from participating in the CRA program and receiving its subsidy. However, the Commission has previously considered circumstances similar to those presented here, either finding no probable cause and dismissing the complaints, or finding the application of Section 112.316 Florida statutes to be appropriate, whereby no prohibited conflict was found to be created under Section 112.3137A. Therefore, where it does not appear that the pursuit of a private economic interest via participation in the program will interfere with the proper performance of the employees' duties in their public capacities, and in light of the Commission's previous findings, I believe that it is appropriate to apply Section 112.316 to negate any restriction that would arise in the current situation via the literal language of Section 112.3137A. In so doing, the employees would not be restricted by this statute from participating in the CRA program and receiving its subsidy in accordance with the program's requirements, provided that they have absolutely no involvement in reviewing, processing, or otherwise evaluating their own applications, or in monitoring their own compliance with program requirements. The draft also cautions the employees to be mindful of Section 112.313 subsection 6 Florida statutes, which prohibits one from corruptly using their position to obtain a special benefit, and take care not to run afoul of it. I now present this draft for your review, and I'm happy to answer any of your questions.
Thank you. Are there any questions? Please pronounce your last name for me so I get it right next time.
I say Ramming, but it's
Ramming.
my husband's name, so.
Okay. I have that same issue with mine. Ramming. Thank you. Are there any questions of Ms. Ramming?
Yeah, I do, and I'm just trying to wrap my mind around it, just so that way. So let's say hypothetically, there's a teacher who, well, let's start over. Let's say there's a school district that uses vacant land that builds affordable housing that's less than the market rate. And then they do it because they want to create a village where teachers can actually afford to live there. So if the teacher is employed by the district and actually takes advantage of this housing, would that be considered a conflict of interest?
It could be, and in this situation, and it really depends, in this situation, these individuals are working with the division, which is their agency, and the CRA directly employs their division. The thing that gives them the quote-unquote get-out-of-jail-free card is that they're in a completely different division or section of that division where they are hands-off completely. So in a technical sense, if you have the literal reading of the statute, there's a conflict here. They would be restricted by 112.3137A, but that's where 112.316 comes into play, to give them the opportunity to pursue a private interest, providing that it will not interfere with their public duties. But in the literal sense, there's a conflict here if we were to just look at 112.3137A.
Mr. Anderson?
If I might, through the chair, just elaborate on that a little bit there, Commissioner. There's not really a literal conflict here. There's really actually no conflict, and it's because the additional statute is laid on the prohibition statute. In other words, if you didn't have 112.316, the so-called construction statute in the Code of Ethics, then you would just have the mechanical elements which would indicate that there could be a problem here. But what 112.316 is intended to do, the legislature wanted to give the commission the ability in certain situations to look at all of the reality and to look at the fact that in this case, these people in their public capacity don't have anything to do with approving their own application or monitoring their own compliance. And in that sense, it's sort of similar to an opinion we had a few meetings ago where two employees of a state university, they worked at the university and the university was their agency, but they had a catering business. And they wanted to sell some catering to parts of the university. And in their university positions, they were computer people. And they were, you know, nerds or geeks or whatever, and that's what they did, and they were good at it. But they had nothing to do with the university's purchasing of catering service.
Yeah.
And so when in your public capacity, you are divorced from the interface with yourself and your private applicant capacity, the reality is like you really don't even have a public job. There's no real duty that you have that you could be tempted to compromise because you're not in the loop on the public side of the transaction or the interface. And the courts have said since early on under this statute that really what's to be prohibited by this statute is when the public officer or the public employee, they wear two hats in reality in relation to the same subject matter, one public and one private. And in this situation, they don't have a public hat because they're not riding herd on their own private relationship. And that's why, in essence, there is no conflict, even though mechanically, without the application of the construction statute, you might rotely have the presence of the essential elements of a conflict when you look at the legislature's overall intent, in this situation, it appears to be completely appropriate to apply the additional statute and say that the final result is that there is no prohibited conflict.
Any
Yeah.
other, Mr. Gilsey?
Yeah, so I'm completely in agreement of it. I'm just thinking of my good commissioner here from Miami, where affordable housing or any opportunities to, I guess what my concern is it really, do we put people who work in public service jobs, who live in very high, expensive markets that say, hey, you now have to choose, either you can be employed or you can't take advantage of an opportunity that's created by taxpayers for the entire community, you know? So I see, I understand and I agree with this, but I guess what I'm concerned about long-term is, does every individual who works for a CRA, who may not be on the processing side, have to have an opinion coming before us in order to take advantage of a 3% or 3% down payment opportunity?
Mr. Anderson, would you like to address that?
Through the chair, thank you. Commissioner, one of the benefits of these types of opinions being issued is that sometimes a situation is potentially inflammatory or it's novel, and it has to come to you for your review and your issuance of an opinion. But when there is a sufficient body of law created, as there is in this area and a lot of other parts of the Code of Ethics, we frequently, because of time constraints and people needing an answer before the next commission meeting, or just because their situation is materially analogous to commission opinions that have already been issued, they don't all have to get on the agenda. And we do quite a bit of guidance to folks over the phone and through letters, but we thoroughly vet their situation and we talk among ourselves and we make sure that, like if somebody from another county that had materially the same situation as these folks came in a couple of weeks and asked the question of us, we probably would not bring it to you. We probably would send them a letter and say, see commission opinion, whatever number this one gets, as precedent, and handle it that way.
All right, great, thank you.
Any other questions? I need to ask if the requesters are here. I know their names were withheld, but I still need to ask. Thank you. All right, may I have a motion to adopt this?
Motion to adopt.
Commissioner Burgers?
Second.
Second by Commissioner Brady. Any further discussion? All in favor of adoption of opinion file 2744 signify by saying aye. Aye. Any opposed signify by saying nay. Hearing none, the motion passes unanimously. Next, move on to file 2745, which will be presented by Grace Schaefer. Is the requester present? No. Thank you. Mr. Schaefer.
Thank you, Chair. Commissioners, I think this is a fairly straightforward opinion request. Concerns whether a particular individual should be considered a municipal attorney, which is a position that has a financial disclosure filing responsibility. He's indicated he performs legal services for the town of Century, and that he's done so for the past 27 years. He states he works as a private outside contractor. The town contracts him to perform work on specific matters that arise. He has no ongoing contractual obligation to the town. He just contracts the town whenever they need his services in a particular matter. He estimates he contracts the town about 5 times a year, provides about 10 hours of legal services to the town each month. And he says some of those contracts overlap in that while he's finishing one particular task and closing out one contract with the town, he may have separate concurrent contracts with the town for which he still owes them services. He's paid for his work on an hourly basis, and he says that even though the town occasionally hires other attorneys to perform work for it, he renders more legal services to the town than any other lawyer. Now, the financial disclosure law concerning Form 1 filers, which is found in Section 112.3145, says certain local officers have to file the Form 1. And it provides a list of particular positions that the statute says will be considered local officers subject to filing the form. And it says any person holding one of the following positions has to file. One of the positions identified is that of municipal attorney. So the question here is whether this requester should be considered a municipal attorney required to file the Form 1 due to his unique relationship to the town of Century. Now, preliminarily, I will say you all found in the past that independent contractors can be considered municipal attorneys required to file the form, even if they're just private outside counsel. He doesn't challenge that. Instead, he raises some facts unique to his situation, as well as a new legal argument as to why he shouldn't be considered a filer. First, dealing with his factual arguments, he indicates he lives 45 miles from the town. He hasn't visited in person in over 2 years, and he only rarely meets with town representatives. He also indicates he's not the only attorney who provides services to the town, and he hasn't even met some of the current members of the town council. Finally, he claims he has no ongoing contractual relationship with the town, securing his ongoing services as the town attorney. But balanced against that, and what the opinion recommends you look at, is the reality that he provides more legal services to the town than any other lawyer, and that he's worked for the town now for 30 years. And he even relates that town consultants were so frequently coming to him for advice on town matters without first obtaining permission, that the mayor and the town clerk had to impose a process by which those consultants would first obtain their approval before they could ever take a matter to him. So this, I think, shows how closely he works with the town, and as much as these town consultants were automatically coming to him whenever they had a legal issue about the town. The nature of his work is also important. He indicates that he does draft ordinances for the town and contracts. He assists the town in acquiring property. He helps the town resolve personnel and disciplinary issues, and he addresses local election law issues regarding the town. So for all practical purposes, he seems to be serving as the town's effective attorney, and I think that to find otherwise would ignore the reality of the significant work that he's routinely performing for the town. Now, he also raises a legal argument as to why he shouldn't be considered a municipal attorney, in that the town's charter doesn't specifically create the position of town attorney. And he claims then that he can't be considered a local officer under the financial disclosure laws because the town's charter doesn't specifically create the town attorney position. Now, there is an opinion in the past where one factor that you all looked at in determining if someone was required to file, you looked at whether their position was created by a local charter. But that was only one factor mentioned in that opinion. It wasn't the dispositive factor. And I will say, if you look at the disclosure law here, it just says a local officer required to file the form is anyone holding the position of town attorney. It doesn't create any particular exceptions just because their position isn't mentioned in the town charter. And also, we have other statutes in the code which are specifically triggered only if one is serving in a specially created office. The fact the legislature chose not to put that language here in the disclosure law, although it placed it elsewhere, at least implies the disclosure laws don't hinge on someone serving in a position created by a local charter. So in closing, the draft recommends you consider the requester here, based on his unique facts, to be a municipal attorney required to file the form. I think this recommendation is in keeping with the language of the law, and it also reflects the spirit of the law, which is to encourage transparency among those holding certain positions in state and local government. I submit the opinion for your review, and I'm happy to answer your questions.
Any questions, Mr. Schaefer? Commissioner Leslie?
I agree with everything you say. I question, does this opinion put this person in significant jeopardy, given, I'm presuming he has not filed, and he has 30 years where he's done this exact work. And so what happens does somebody wants to file a complaint with respect to his past behavior?
Through the chair, I think factually that's not going to be the case here. He's indicated that since 1990, which preceded his service for the town of Century, from 1990 to I think 2014, he served as the outside counsel for the city of Gulf Breeze, and that was a position that he agrees he has to file the form for. From 2014 to 2018, he served as the mayor of Gulf Breeze, so he had to file the form then. And then when he received notice this summer that he was on the list, based on his connection to the town of Century, it surprised him, but out of an abundance of caution, he filed the form, and then he submitted this opinion request. So I don't think that's going to be a problem for him.
Okay, thank you.
Mr. Schaefer, how did he get on that list? that he had to file?
His coordinator must have placed him on it, and I have checked, Chair, our records. It looks like, he may not realize this, but since 2006, there is a dual basis for him filing, based on his service to Gulf Breeze and Century. So since 2006, his obligation to Century have placed him on the list.
Okay, I have a couple questions for you. I have a lot of concerns about this. I actually think this is a slippery slope, could have a chilling effect on what attorneys will do. Because I work with a lot of outside attorneys for different cities. So you keep saying under these unique facts, but those unique facts could change year to year. Next year, he may only be do 30% of the work. But yet his coordinator's gonna put him on there every year. Is he going to have to look every year and make the determination as to whether he needs to file?
Well, that's a good question. Really, this opinion, Chair, just reflects the facts that are presented to us now. A large part of this is based on his indication that he provides more legal work for the town than anyone else. I think if in the future that is not the case and he wants to request another opinion, I think that perhaps a different result could be reached. But based on the facts he's presenting to us now and looking at the reality of his situation, I felt that this was the best possible advice I could give you all.
Also, you mentioned in a footnote that, that to the extent this differs from CEO 85-44, we should recede from that opinion. Can you explain that?
Sure. That's footnote 3. It's on page 4 of the opinion. 85-44 dealt with another situation where you had a private attorney providing services, in that case, to a small city. I do believe that 85 opinion is factually distinguishable, because in that particular case, that attorney wasn't charging the city for any of their services. So I just think based on the facts, it's distinguishable. But to give you a complete answer to your question, going beyond that and setting that aside, that 85 opinion, again, dealt with a situation where you had an attorney who was, in that case, the only attorney providing services in that city, and he was doing so about every other month. Under those circumstances, perhaps in combination with the fact that he wasn't charging the city, the commission found he shouldn't be considered the municipal attorney. I just think going forward, if you have an attorney who's providing services on a frequent basis to a town or a county more than anyone else, that they should be at least considered to be a disclosure filer. And I think to the extent that this opinion may reach a different result from the 85 opinion, the reasoning of this opinion should supersede the reasoning explained in the 85 opinion. Although going back to my initial point, that 85 opinion is factually distinguishable because that individual wasn't charging.
Thank you. Any other questions? Do I have a motion on this?
I move to approve the recommended opinion.
Do I have a second? Motion by Commissioner Lesnoff, second by Commissioner Gilzine. Comments on this motion? I do. Again, I have a lot of concerns about this, only because I do work with a lot of private attorneys that do contract. I've even contracted with cities before on minor things, and I think they're not going to know. And I'm not sure every coordinator is going to know. And I just think this is going to have some impacts that are unintended on private attorneys. And it may even have a chilling effect on who towns can hire. So I will not be supporting this. Any other comments? All in favor of?
I was just going to add, I think it really depends upon how narrowly you view the opinion or how broadly you view the opinion. When I read it, I was thinking it was narrow in scope and limited to these facts, which also could lead to more requests for opinions on the other end of it. So I will be supporting that. I read this more as narrowly tailored to this individual with these facts.
All in favor of approval of this opinion, signify by saying aye. Aye. All opposed, nay. I'll be voting nay. Motion carries. Next, we're file 2746, which will be presented by Chris Anderson. Is the requester here? All right, thank you. Mr. Anderson?
Thank you, Chair. What we have here is a city is in need of a city manager, and they've had a situation where they've hired a recruiter, and they've had a process where they've winnowed down 40-some-odd applicants to, I think, 5 finalists who may not actually totally be finalists because they have the ability to consider other people also. The ethics part of this is that one of the city commissioners who will have a role with the other city commissioners and ultimately approving and/or hiring a city manager. In his job, he works for he works for the FBI. And one of the applicants for city manager is his supervisor over at his FBI job. And the opinion is discussing the voting conflict law as well as the conflicting employment or contractual relationship law. In terms of voting conflicts, let's say that there would be some vote that would affect his supervisor at the FBI. That his supervisor is not a principal by whom he is retained, it's not his relative, there's no indication there's going to be any economic effect on the commissioner himself. So the facts of this matter don't trigger the legal elements of the voting conflict law, so the opinion says there would not be a voting conflict. In terms of the draft opinion says that. In terms of the conflicting employment or contractual relationship statute, the first part of that statute is only triggered if the public official, here the city commissioner, holds employment with a business entity or another government agency if that business entity or that government agency is regulated by or doing business with their government agency. In this case, the question is, does the city regulate the FBI? And I think probably they don't. They probably wish they did, but I don't believe they do. And so that part of the statute mechanically is inapplicable. And then the second part of that statute, which could be based on any employment or any contractual relationship that a city commissioner or other official would hold, the conflict can be present there if the reality of the situation is conflicting. And the draft articulates that it is not a conflict because what you have here really is credentialed employment at a federal agency, and it's difficult to see how the city commissioner would have any sort of actual conflict merely because his supervisor at this credentialed agency, not some crony little company or something where he rises and falls purely at the whims of somebody, is an applicant. And you have a very objective process going on here too with the recruiter and the vetting and that sort of thing. And everybody apparently that has made the short list, including the one that supervises the commissioner at the FBI, meets the qualifications. And so the upshot here is that it's proposed that you find that there is no voting conflict and that there is no conflicting employment either in this situation. And it's offered for your consideration, and if you have any questions, I'll be happy to try and answer them. Thank you.
Any questions of Mr. Anderson?
Move to adopt the opinion as presented.
Motion by Commissioner Brady. Do I have a second?
Second.
Second by Commissioner Berger. Any discussion on the draft opinion? Seeing none, all in favor signify by saying aye. Aye. Any opposed signify by saying nay. Motion passes unanimously. Next, we move on to consideration of financial disclosure appeals. Item 6 on the agenda consists of the appeals of automatic fines under the financial disclosure law. There is no appeal in which the applicant has asked to be heard, thus we'll take up the no hearing appeals. Are there any items that any commissioner would like to take off this list before a vote en masse?
Move to vote on mass. We dismissed the fines in all cases due to lack of appropriate communication regarding the need to file.
Do I have thank you, sorry. Do I have a second?
Second.
Motion by Commissioner Brady, second by Commissioner Berger to approve all the opinions as drafted in item 5. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries unanimously. Moving on to section 7, consideration of second order on requests for extension. There are 3 of these. They are requests for extensions to file disclosures. They are self-explanatory from your written materials. If there are no questions, do I hear a motion?
I make a motion to adopt the recommendations for good cause shown for extensions in mass for items A, B, and C of section 7.
Actually, I'm mistaken. C has been stricken from the agenda.
A and B.
A and B. Do I have a second?
I'll second that.
Motion by Commissioner Berger, second by Commissioner Brady to approve A and B. Any comments or questions on the motion? All in favor signify by saying aye. Aye. Any opposed signify by saying nay. Hearing none, motion passes unanimously. Next, we have item 8, consideration of order declaring financial disclosure fine uncollectible in Ray Ruth Campbell. This is self-explanatory from the written materials. Do I hear a motion?
Motion to adopt the recommended order.
Okay, motion by Commissioner Lesnoff. Do I have a second?
Second.
Second by Commissioner Berger. Is there any discussion on the motion? All in favor of the motion signify by saying aye.
Aye.
Any opposition signify by saying nay. There's none. Motion passes unanimously.
Can I ask a
Yes, sir.
question to the staff? Do we ever go after estates?
Through the chair, it has not been our practice to try to dig people up, not yet anyway.
At this point, I'm going to suggest we take a 10-minute break before we go into the consideration of legislative recommendations. Thank you.
Great job there, you're moving so well.
I'm sorry.
No, that's fine, that's fine.
Legislative recommendations. Mr. Anderson will briefly go over our legislative recommendations from past years and explain what our options are. And then we'll hear from any members who might have issues they want to add. Then we'll vote on what we want to recommend, and if anything to delete, and how to approach our legislative issues. Mr. Anderson?
Thank
I see that.
Members, thank you, Chair. Members, you have a memorandum from me dated August 28th. It's titled Proposed Legislation for 2020. And this is the kind of memo that you've gotten in years past. And of course, the legislature will be meeting in January this year, and the committee weeks, I think, are starting this week coming up. And so it's an earlier thing. And as staff, and that is going to be interfacing with the legislature, and that's going to be myself and then Deputy Executive Director Carrie Stillman. And Carrie's got a lot of experience over there from past years. One of the things we'd like to achieve from you today, if you see fit, is some hard votes, some definite positions on certain things, so that we'll be able to express at the legislature not just informational points as an informational speaker, but we'll be able to say over there that this is the commission's position on this topic. This is the position of the Ethics Commission. And also, this will be a written transmission that will go over to the legislature here in the near future, and that's based on the statutory requirement that recommendations be made to the legislature each year by the commission. Now, some years, it's been kind of a not very populated, if you will, universe there of things that have been recommended, rather short. I don't think that it's ever good to have an extremely long list of positions, because, you know, it's hard enough to get ears over there for anybody on anything, and the more stuff you're asking about, the harder it is. So to the extent that you could give us solid direction on certain points that you would like emphasized and you'd like to take a position on today by voting on certain things, that would be really helpful. And I think in past practices or past years, it's been shown that when the commission takes a position officially on a certain issue, it's heard louder at the legislature than if the commission is silent on various points. A big part of interface with the legislature, of course, is not just what you would seek to promote in particular, or a particular thing or two that you would seek to preserve or to be against things that would destroy existing standards. You don't know what legislation might come up from what corner or what time. A lot of things just happen. And so there is a lot of playing defense in regard to the commission staff's interface with the legislature. And also in past years, there have been like legislative committees of the commission, like a subgroup of the Ethics Commission to be the legislative committee. And then one year, I think, and it might have been Commissioner Brady, if I'm not mistaken, maybe was individually authorized to speak for the commission if need be on maybe something that's not expected. But if you come forth today with particular hard positions, then you already have collectively spoken on those things. And as staff, as your agents, we can, solidly relate those positions either for or against certain things that you may decide to back or be opposed to today with concrete votes. But anyway, the things that are not on the list this year in this memo, and it doesn't mean you can't add them, and you can add things that aren't on this memorandum. This is just a point for discussion, but it is based on the practical reality of the past happenings, the past few years. Two things that I did not put in a memorandum that were on there last year, and with the exception of these two things, this memorandum is pretty much identical to what the commission received from Ms. Doss last year. But the two things that aren't on this year is a proposal to change the burden, or more accurately, the standard of proof in ethics prosecutions. And years ago, it was sort of uncertain as to whether the standard of proof would be clear and convincing evidence, which is a real hard standard that's common in administrative proceedings, or if it would be preponderance of the evidence, which is a very weak civil standard that's easier to prove. And for many years at the Division of Administrative Hearings, they would come out with recommended orders when we'd try a case over there. The advocates would try a case over there, and they'd say, we make these findings regardless of whether the standard is preponderance of the evidence or clear and convincing evidence. They just wouldn't commit to it. And then eventually there was a court case, Latham versus Commission on Ethics, where the court said that because the ethics statute was penal in nature and it could hurt somebody's reputation, you could have fines and things, that the appropriate standard was clear and convincing evidence. So the court has determined that's what the commission's prosecutions operate under, and that's where we are now. Of course, the legislature does have the ability to change it back to a preponderance of the evidence, but I didn't feel that ought to be something that we should be using our time for, because frankly, I personally think that when you're in a penal situation and your reputation could be hurt, that you ought to have it proven against you by more than just a mere greater weight of the evidence or a preponderance. So I'm personally not uncomfortable with the existing standard, and I don't think there would be a lot of traction in the legislature to put a looser standard on that. So that's not included in the memo as a recommendation. It seems like that would kind of basically just be time not well spent to lobby that topic. Also, another matter that was in last year but is not in this year, and probably just because it's so darn complicated to administer, is applying the ethics laws to a whole host of privatized government functions. And one of the phenomenon over the last 15 or 20 years in Florida, and I guess other places too, is that things that are traditionally within government, traditional government functions, a number of those have been partnered or privatized, and an effect of that is with the jurisdiction of the Code of Ethics and the Commission on Ethics, most of your prohibitions have as a necessary element that the actor be either a public officer or a public employee. So when something is privatized and you have a nonprofit or a for-profit, some kind of private entity doing what used to be done within government, then you lose that jurisdictional element, because the actors are not public employees and they're not public officers for the most part. They typically are employees or officers of a private corporation. And so the rug's been pulled out from under the enforcement of things in certain areas. But the legislature, to their credit, they do see this, and they have brought some or all of the Code of Ethics to bear on these privatized functions. Sometimes it's a little bit later than when they privatize the substantive function, but like, for example, with charter schools, I believe originally they may not have had any ethics controls, but because they are doing what traditionally was a core government function, public education, to some extent they're performing that, then in the K through 20 education code, the legislature put in through the back door applicability of certain parts of the ethics code to the officers of charter schools and certain actors of those schools. And so that is out there, and it has been done, and the legislature kind of does some of that on their own. Some of it they do at our prompting. Another example is privatized city managers, where we had some cases years ago where a corporation was hired as a city manager, and there was nobody that was a public officer or a public employee that could be held accountable under the ethics laws for things that might not be ethical. And so the legislature passed what's now codified in 112.3136 Florida statutes. Certain parts of the ethics code apply to a corporation and certain of their officers and actors that supply the chief administrative or chief executive function to local governments, be that municipalities, special districts, et cetera. But I felt that, and I think it was felt last year too, because I don't think that was in last year's final package, even though it was in last year's memo, that it's just too big of a task for us to try to lobby on and do this broadly, and that that maybe it's better to see if there is a sore spot somewhere like we did with the city manager thing, and maybe take those things as they come along, and maybe also depend somewhat on the good faith of the legislature to see these loopholes, if you will, and close them. And in that regard, you know, it kind of depends on, I mean, everything's not the same. I mean, it's easy to say that a city manager used to be an employee and now he's an employee of the government, now he's an employee of a corporation. Some of these other things are maybe not as traditionally governmental. They're more modern, they're more progressive. And I don't think anybody ever wants to get to the point where you have an FDOT road contractor that's laying asphalt to be under the code of ethics. I mean, that's just a market effect right there. But there are things that do come up, but I felt that that in terms of lobbying effort and narrow focus and the ability to get things done as well as beat back things that might be bad, that we don't want to have too many things, and I kind of thought that the burden of proof, like I mentioned, ought to stay the same, and we ought not attempt to change that. And I think it's just too big of a task to go at the privatized governmental function idea in any great way this time either. So those two are not in the memo. Now, what does remain in the memo from last year are several things. One of which is number one on the memo is on top of page 3, titled Conflict of Interest. And what that comes from is that one of the main provisions in the Code of Ethics is conflicting employment or contractual relationship. And one of the essential elements there is that no public officer or public employee shall hold a conflicting employment or shall hold employment or a contractual relationship with any business entity or other government agency if the business entity is either regulated by or is doing business with their governmental agency. And the statute does not define contractual relationship, and so the Ethics Commission over many decades has had to look to the substantive law of contract, be that statutes, be that sometimes administrative rules that bear on who's in privity with whom, and case law as to what is a contractual relationship and who has the privity, who holds it. Because due to the fact that that provision, along with the rest of the Ethics Code, are statutes that are penal in nature, they're strictly construed or narrowly construed. And you cannot say that there is a contractual relationship when in law, in fact, there is not one. And so what that has resulted in is say, for instance, a natural person, a human being, a sole proprietor, somebody without an LLC or without a corporation, they get hired by a company, and that company is doing business with their public agency. Then they have a violation of the Code of Ethics unless they, come within one of the exemptions or something like competitive bid or sole source. But they have a conflicting employment or contractual relationship because they either contract with as a natural person or they're employed as a natural person with a company, a business entity that is doing business with their public agency, and that's a violation. But if you add to that reality that that same person And I think as is in the example here, like Council Member A, he couldn't work personally for the company doing business with his city. But if he forms Council Member A Inc. or A Inc. and he owns 100% of it, and it contracts with his city, then he does not, under the law of contract, have a contractual relationship with his, with the business entity that his company contracts with, if that other business entity contracts with the city. So it's a kind of a mockery of the reality based on the technicality. And what this would seek to do, and this has been long sought out, it hasn't had a whole lot of traction though, because frankly, when you get to 112.313(7)(a), that statute is not just about what I just mentioned, it's about a lot of other things. And it has special language in there that goes to members of the legislature, and when they have a conflict and when they don't. And it has a lot of other language in it. So I think that because it's a complicated statute, there's been a reluctance to touch it at all. And I don't think I've ever seen it amended the whole time I've been working here many years. But that is something, though, that I feel like is worthy to seek approval of in legislation, because it's just ridiculous for Council Member A to have a problem if he works for Company B that's contracting with his city, but he doesn't have a problem if he has a 100% family corporation that contracts with the business entity that's contracting with his city. And so that is something, and you don't have to vote right this minute, but Carrie and I certainly think that that's something worthy of an affirmative vote of the commission to authorize us to pursue and lobby in a solid manner, that the commission's position is that they'd like to see this loophole closed.
Mr. Anderson, would you take questions one by one on these instead of going through the whole thing?
Certainly, whatever's the pleasure of the commission.
Does anyone have any questions for Mr. Anderson as to the conflict of interest number 1? Just wanted to check, because
Sure.
it is, some of these are confusing. Remember, go ahead.
Certainly, and I might add to that, through the chair, that, you know, we have sought when we can to ameliorate this absurdity of, you know, a wholly owned entity being a total buffer like that, and there is case law out there that will create the contractual relationship or the privity, even if one has a corporation. Like, for instance, if one is professionally licensed, like say they're a land surveyor and they got a license, and they're doing work for somebody, and they're the surveyor or the engineer that's doing the work for the client of their firm, then there's case law that's, and a commission opinion that support the notion that they do have a contractual relationship because it's under their professional license. But when you get to general corporations where you really don't have licensed professionals, that privity is not there, and there is a glaring loophole.
Thank you.
And then label number 2, there, and there's suggested language for that too that follows with strike-throughs and underlines, that kind of thing, to be, you know, offered. And when you do these, whatever you decide to promote, excuse me, you don't have to promote specific language. Just give the concept on the point, and then the specific language can be ironed out later, if I'm remembering that correctly. Is that right, Carrie? Right. So point number 2 here goes to the issue of attorney fees and ethics proceedings. And this is the thing in 112.317 in the Code of Ethics, where a respondent, an accused person, after a case is over, they have the right under that statute to request attorney fees against the complainant that filed a complaint against them. And the standard for that is not a prevailing party standard, but rather the respondent will have to show that the complaint was filed and the complainant knew they made something up, or they very sloppily or maliciously, in an inaccurate sense, filed something that they knew at the time they filed was either untrue or very sloppily made. And the respondent can seek fees. And we feel that we have seen a chilling effect due to the progression of this fee statute and its litigation over the years. Like when it was first on the books, in order for a respondent to get fees, it had to be shown that everything in the complaint was false or maliciously pled, and that it was totally frivolous and there was no need to investigate for any reason. And it was hard to get fees then. The commission went for a number of years when no attorney fees were awarded at all. And then the statute was amended to make it more fee-seeking favorable for respondents. And it got to be where it is now, where you only have to show that some part of the complaint, material to a violation of the Code of Ethics, was maliciously or falsely pled in the complaint. And it's easier now, but it's still a pretty high burden for the respondent to even plead one of these things accurately, much less get it awarded. And I don't think there's been a huge abuse of that, but I think though that or maybe no abuse, but not a real big use of it. But I think it has been sufficient, the awards and the nature of the fee statute and the warnings that are on our complaint form from past commissions that put some big warnings on there about, hey, complainant, you know, you're liable for attorney fees if X, Y, and Z happen. A number of us at the commission have talked to people very frankly on the phone who are not nutcases, who are very legitimate people, who had very legitimate complaints that they would have made with the Ethics Commission, and they frankly told us, we're scared of that attorney fee statute, and we're not gonna bring this complaint because we just don't wanna risk it. And we'd explain to them, well, you know, it's not a prevailing party standard. You've got to be malicious in your filing or false. And they said, well, we're just not going to risk it. And we think we've seen an uptick in that, and we think we probably missed some good complaints because people had been chilled. So on the issue of attorney fees, the proposal would be that there be a change in the statute that would allow a complainant, if they're taken to a DOAH hearing or they have an attorney fee petition filed against them from an ethics respondent, that the complainant, if they win over at the Division of Administrative Hearings or they're determined not to have maliciously or falsely filed a complaint, in other words, the respondent does not prevail and does not get the respondent's fees, that the complainant would be able to get their attorney fees for having to defend. It's sort of like, you know, I maybe drug you in under an ethics complaint, Mr. Respondent, but then you drug me into a fee petition that didn't have legs, and I had to pay a lawyer to defend myself there. And right now, there's really kind of an uneven playing field because a lot of times respondents get their fees paid by the governmental entity and or insurance companies that are insuring the governmental entity and its officials, and complainants are just left hanging out there in the wind to bear their own cost. And we do think there's been, and fees, and we do think there's been a chilling effect. So that's something that's been on the mind of the commission for several years. And there's suggested language for that, which is just one or two sentences there on page 6 of the memo. It wouldn't take much to do it. And it would make it a more level situation and maybe cause us to get complaints that are valid complaints that we have been missing out on because people are paranoid or unduly cautious. Any questions on that from any members? Moving on then to item number 3, which top of page 7 of the memorandum deals with the voting conflict law, and that's the one that is codified in 112.3143 Florida statutes, and it was amended fairly substantially about 3, 4, 5, 6 years ago. And there's always been some differences in the application of that law between like the state level and the local level and appointed officials versus elected officials. And so it's really probably more complicated than an ideal voting conflict law would be. And in essence, what the proposal would be, if the commission decides to go that way, and there's some draft language on there which gets more involved because the statutes are rather lengthy, and they follow on pages 8 and following in the memo. But right now, the law is much more, is stricter at the local level, like say city council people, county commissioners, school board members, when they have measures that they're voting on. It's stricter than it is, say, for this body as a state level body, or members of the legislature as a state level body, or any other collegial body that votes at the state level. They're subject to a lesser standard than local officials. And similarly, appointed officials are subject to a more rigorous standard under this law than elective officials. And one example of that is, say at the local level, and you're an elective official, right now, the way the law is, you could advocate till you had a sore throat or were blue in the face on an issue or a measure that would affect your relative or your employer or yourself. And as long as you announced that you were gonna abstain from the vote, and file the voting conflict form, you'd be in compliance. Whereas an appointed official would have to do disclosures up front before they start running their mouth in advocacy for the measure. And so that's a difference, you know, and you say, well, why the distinction, you know? I mean, aren't appointed officials pretty important, and aren't elective officials even more important? And I guess probably the thinking behind that difference may be that there's a direct check of the voter public on an elected person when they come up for reelection, but, you know, how often is that? And so for uniformity, it's been felt that the same standards should apply to appointed people as applied to elected people when they're on collegial bodies that vote. And then in the state, local difference, at the state level, a person is prohibited from voting on a matter only if it would affect their own personal economic interest. If it would affect the economic interest of their relative, their employer, their client, or certain others, they're not required to abstain from voting. In some of those situations, they have to disclose their relationship, but they're not prohibited from voting when the effect is a vicarious effect or an effect on somebody connected to them, but not themselves personally. Whereas at the local level, the officials have to abstain not only on a matter that would affect the official personally, their own pocketbook, but also if it would affect the pocketbook of their relative, their business partner, their employer, their client, various others. And again, you know, maybe the reasoning behind that is that, well, at the state level, the issues are so macro, there's so many people affected, that maybe it ought to be different than it is at the local level, and the local level, maybe there's more cronyism than, I mean, maybe a given city council is more cronyistic, if that's a word, than the legislature is, I don't know. But anyway, there is a difference, and the commission and staff, we felt that, well, you know, you got this big, long voting conflict law. It's got all these little subtleties and nuances. It requires us to have 2 voting conflict forms, an 8A for state officials, a Form 8B for local officials, a whole laundry list of different instructions for appointed officials on the form versus elected officials. Why not simplify it? Why not make everybody subject to the same standard? And also, there's a thing in the law, too, where if you're in the legislature, you can use some other kind of voting conflict form that's created there, or some ad hoc mechanism, and you don't have to use the 8A like other state people would do. And this really is a search for uniformity and simplicity, because, you know, if you can't vote on something, why should you be able to speak very eloquently on the matter when it's going to your own pocketbook or that of your relative, your employer? This is a tightening up, a making uniform, a simplifying of the voting conflicts law. This, I think, is a very worthy thing to pursue, and a lot of that's laid out here with suggested language on page 8, like I say, and following. If anybody wanted to ask about that, I'd try to field it if you have any questions. Yes, Commissioner.
Have we pursued this before?
Let me double check on that.
Mr. Brady?
Yeah, I'm pretty sure that's been in the
We
last
have,
couple of years.
Since I've been here, we have.
It has, yes, it has been done. I don't know how intensely it's been pursued at the legislature, or whether there's been a real hard vote on that. Ms. Stillman, do you remember on that?
Commissioners, with our legislative recommendations the last few years, there hasn't been a lot of traction with the particular things that we've come to. The last item he'll talk about, enhanced financial disclosure, that had gotten in some bills and debated, and there was some voting conflict language that appeared in different bills, but nothing that passed.
Mr. Anderson, why wouldn't we try to hold the state public officers to the same standard as the local officers instead of relaxing local officers to the state level. Why wouldn't we do it reverse?
Well, if I was misunderstood or if I misspoke, I apologize, but my intent has been that the state officers would be brought into the more strict thing and not
Okay.
that the local officers would be
Okay.
relaxed.
All right, I misunderstood.
Are we having a period of question and discussion on each, or are you going to have
Just
discussion later?
questions for
Gotcha.
Mr. Anderson. yeah.
Gotcha.
Any other questions of Mr. Anderson? Seeing none?
And through the chair, if I might, I think, you know, I mean, whatever y'all would like to do in terms of the process, but I think like the discussion thing might come after I finish these other 2
Oh,
points.
right, that's what I was asking,
Yes,
just the
ma'am.
process of how
Thank
we
you.
were doing
Right,
that.
right. And then, item number 4 on the memo, which is on page 10, is, titled, appearances before boards by a board member's firm colleague. And what that is that's not anything that needs affirmative legislation to enact it. That has been the commission's view of an applicability of something that's already in the ethics code. And it comes from the conflicting employment or contractual relationship statute, 112.313 subsection 7A. And the commission has long construed that statute to prohibit, among many other things, to prohibit a person being, for example, on a county commission, and then they or a member of their private firm representing a client in front of their very same county commission. And it's been argued that, oh, okay, well, if they just abstain from voting, then okay, it's all okay, you know, it's good. And it doesn't matter that they leave the dais and go down to the podium and speak back to themselves, or that their firm members at the podium speaking back to their brother or sister or comrade in the firm, that is a voting conflict law takes care of it. And that's never been the commission's view, and we've had cases where people have argued that, and the courts have not seen to disturb our findings that 7A applies also, and, you know, you have an incohate situation there. Because everything that a member of a collegial body does is not just voting, not just advocating from the dais, not just speaking. It's often what they don't do, or what they would have done if they had not had the private contractual relationship or employment that was over on the other side of the coin. And the lead case on that statute is from the 4th TCA from 1982, which is called Zerwick versus Commission on Ethics. And it has language in there borrowing from federal law on the time-honored notion that what a conflict of interest is that a person cannot serve 2 masters at the same time. He will hate one and love the other. That you cannot wear 2 hats in relation to the same subject matter. And so how can you be up there and be fully effective and be fully objective as a member of a board when you yourself or somebody else from your private firm is representing a person on a matter that's a matter of your public board? It's inherently incompatible. It's insidious. It's an incoherent eating away of objectivity. And it just can't be cured merely by a voting abstention. And the commission has always felt that way and always applied the law that way. But there are bills that come up from time to time, some of them in the last days of the session without going through any committee, that would seek to relax that standard. And the commission has felt they don't want to do that, and as staff, we certainly very much would like you to go on record saying that you oppose that, so we'd be able to say the commission is opposed to any such thing if such proposed legislation were filed. In my mind, that's almost a total no-brainer. I mean, it's like nepotism in a way. I mean, when you have a certain affinity that's either in blood or it's in money with firms and people and clients and relatives, it's like Pavlov's dog. You just can't get away from it. When they show up, you salivate their way, and the public be darned. You know, it's the objectivity's out the window. And so that's more of be playing defense on that. I guess if I was from up north, I'd say defense, but I think we'll be playing defense on that. But anyway, number 5, anybody have any questions on that? And then point number 5 which would be, again, an offensive matter or a bill or something, you know, to push the commission, try to, you know, see if maybe we could get a sponsor on different things. Enhanced financial, or look at bills that are out there. Enhanced financial disclosure for elected municipal officers. And what that is about, and that has had some legislative history that it was never enacted, but you got a lot of counties in this state. Well, all county commissioners have to file Form 6, and elected county officers have to file Form 6, like tax collectors, sheriffs, property appraisers, clerk of court, school board members, those types. But in the municipalities, they file typically Form 1, unless you're like the city of Jacksonville, because, you know, they made their hybrid government, and there's a special act that makes them file Form 6, and rightly so. But there's a lot, all your municipalities, for the most part, most of them, they file Form 1, which is a far lesser standard of disclosure than a Form 6. Now, you members here, as members of the commission, you file Form 1, and I think that's perfectly appropriate for you. I don't think you should have to go to Form 6, because you do a very important function, but you're not handling a lot of money, you're not voting on all this stuff all the time that localities are doing. And a municipal governing board member and municipal officials within City Hall are completely analogous to county governing board members and county officials within the county courthouse. And so it seems in logic very appropriate that these municipal officials should also have to file Form 6, the more detailed disclosure. It's just great for transparency, much better form in the context of those types of officials. And so anyway, in the past there, I think maybe it was last year, might have been a year before, the problem that happened with it was that the wording in one or more of the bills had sort of a real unwieldy thing about population numbers of a given municipality, and then they would have to file a Form 6, but if they dip below that population threshold in the next year, they'd go back to Form 1, or, you know, all that kind of stuff, which is very, very hard to administer. So it's our view at the staff level here, and we'd like it to be your view if it's the will of the commission, that the kind of legislation that would be good here is legislation applied to all elected municipal officials with none of these population thresholds or these floating numbers or anything like that. Just a straight application. And that is something that we feel is a good point also. And that was the last thing that I had listed, if anybody had any comments on that or questions.
I just have a question on the last one, which I think is a really good suggestion. My question is, we have several towns in Brevard County, and I don't know why they're towns versus a city, but one of those towns collects no taxes whatsoever. And so this wouldn't necessarily be appropriate for them. They have 1,000 people in the jurisdiction. I don't know if a town designation means anything or can be incorporated, because there are a lot of very small towns which this might not be appropriate.
Thank you, Chair Rosanka. I hear your point there, and on another statute a number of years back, I think I did some research on the difference in towns, villages, cities, that kind of thing. And I think all of them technically are municipalities.
Okay.
Now, you do have some odd things like you just mentioned. I think, though, that if that becomes the preoccupation, we could easily fall back into this population stuff, and, you know.
I just thought it might be a distinction that we could use. I'm not saying it has to be. I was just curious. Commissioner Wesson?
Yes, similarly, when you mentioned the population distinction, I thought of, you know, the little town that has, you know, less than 1,000 people. They don't take taxes. They have, you know, the soccer mom is also the, you know, the mayor, the presiding, and it becomes onerous, and people become fearful of all those requirements. Maybe the taxation issue is something where you don't, you know, you're not deciding on certain financial matters or something that would not discourage participation in government due to, you know, a greater bureaucracy. And I'm assuming that's why they had the population distinction. Is that the reason?
It might be through the chair. I think Ms. Stillman has a point on that, if she
Ms.
could be
Stillman.
recognized.
I was just going to mention that what was going on with the legislation that was filed last year related to revenues related to a particular municipality. And if they were above a certain amount, then it would be a 6, but they'd have to be above that amount for 3 years, and then you'd have a 6, but then if it dropped below for a few, and for implementation purposes, it's complicated enough to administer the financial disclosure thing, and the commission felt like at the time, it would make it more difficult for officials to comply. They wouldn't know if they're a 1, and they wouldn't know if they were a 6. And what the commission had discussed previously is, you know, just because someone lives in a small town doesn't necessarily mean that their citizens are entitled to less transparency by those officials, and that sometimes perhaps in a smaller community, the constituents, the citizens, are maybe more affected or more plugged into the specific decisions of their elected officials than perhaps those in larger metropolitan areas. So there are arguments clearly to be made on both sides. I'm sure the League of Cities would have a voice in the process as they have in the past. But that's sort of been the history of what's gone on. And particularly with the electronic filing system coming in, we want things as narrow and streamlined as possible.
No, go ahead.
Just further, thank you, Chair. As Ms. Stillman said, you know, there could be some pretty solid opposition to this from groups connected to municipalities, not because they don't like ethics, but because there has always been the fear that you will have a lack of people to serve, particularly in smaller places when they have to do these onerous disclosures. So I think that some of the things I mentioned here before this item 5, they might draw opposition, but it might be from more of an insular or special interest class. This proposal could draw opposition from a broad-based group like the League of Cities, for example, and not to say anything negative about them, they're a fine group, but they have their concerns, and you know, if you want to not necessarily do a lot of these, but just keep things more focused, this is one that I could see having, you know, some pretty organized opposition against it, even though it's a very worthy thing, I think, to do.
I'm sorry,
So
Commissioner Berger.
my question is really, what is the purpose of this exercise? And I'll put it in this context. You've got 5 proposals, which to me is not really that many. 5's not really a lot. And all of them have some really good things in them, and I'm guessing, you know, part of it is to deter behavior and or punish behavior, and also to instill confidence in the public. So when we look at these 5, is the priority what's going to affect the most people, or is it what's going to move the needle? Meaning, most likelihood that something's actually going to be accomplished. I don't have a problem with any of the 5, and speaking of the last one, you're talking about, really, in my mind, transparency and uniformity, meaning across the board, same standard, and disclose. People are going to ultimately put in period, you know, wherever they are, so I'm not overly worried about people put in or a shortage of personnel, but uniformity means something to me because it's across the board for everyone, and transparency means something to me. Again, it's the same standard, it's the same requirements. So are we trying to narrow this list from 5 to less, or are we just discussing whether we're in agreement or in disagreement of the 5?
Well, this memo and the things on it are really just a conversational starting point, because you can add things that aren't on this list at all, and you don't have to accept anything on this list, but it is kind of based on the history of things that have come about through logical discussions about what's needed, what's been seen as things that ought to be tightened up, and frankly, the practical history of moving forward or any legislative appetite for various things. But it's just a discussion thing, but we would, and I can go back through this a little bit, you know, and say what I think maybe is more important of these things, but I think they're all worthy. I do think, though, that if we add anything to this list, even though it's only a list of 5, it would make it tougher, because it's just, there's things that are going to have to be defended against, and there's only so much attention over there for ethics or anything else. And I think probably we ought to keep it at 5 or less things like we have on here, but of course, that's certainly the will of the commission.
What I would like, go ahead, Commissioner Berger.
Well, I was just gonna say, for purposes of discussion, my opinion, position is that all five are sufficient, they're valid. I've been here a couple of years, like Commissioner Rosanka. Any more is too much, in my opinion. And if we're talking about what we've done in years past, where we appoint someone to assist with that, my opinion has always been local people. We have two from Tallahassee because that's the most efficient way to try and get something accomplished.
I would, what I would like to do at this point, we do have a comment card from Mr. Herron. I'd like to hear from him. And then I would like to go through and see, my process, if we go one by one and get a yes or a no. And it's also my position that they're all things that will be pressed as time allows. Because one may come up in the legislature, the others might not, we might not have an opportunity. And then to select someone that would be the point person or a point committee. So I'd like Mr. Herron to speak.
Thank you, Madam Chair, members of the commission. My name's Mark Herron. I'm not here representing any specific body or group. Most of you know me. I've been around the commission. I've been a member of the commission. I have fought some of the same battles you have fought, and I fought against you in some of the same battles that you're talking about fighting as well. I'm going to take your admonition early in the meeting to be brief and not to extend my comments, so I will focus as quickly as I can. On the first proposal, I would suggest that, I'm not suggesting any changes in the language. I would suggest that you format it a little differently. And the reason is that when you talk about 112.313.7a, in your opinions, you're always talking about the first part and second part of it and how the standards differently. I would suggest that you take this paragraph that you're talking about amending on page 4 and break it into 7A1 would be the first part of 7A, where you start and change the second part at about midway down, where it says, and no officer. That would be like subparagraph 2. And then make your new additional language a subparagraph 3, because it's going to apply to everything above as I read it the way it's formatted. That's a format change. With respect to the, and you can expect this from me, with respect to your proposal on attorney's fees, I think the proposal is misguided. I think the proposal is reactionary. And if there's any chilling effect that has come as a result of the attorney's fees, it's because of this commission putting on its form in big red letters that you're going to be liable for attorney's fees. What has been left out of the discussion to this point in time is that this commission is the gatekeeper on whether petitions for attorney's fees go forward. And I would suggest, and my recollection is that this commission weeds out and refuses to move forward most of the attorney fees petitions that are filed. You guys have adopted a very aggressive approach to denying these requests, and in most cases, it's the correct response. But to basically say that because a public official or a series of public officials have been the subject to repeated challenges and with malicious and untruthful complaints with which they or their agency or their insurance policy has to spend public money to defend, and then basically say, hey, if you're unable to prove it over there, now the agency or the public official is going to have to pay that, is, I think, misguided. And again, I think that, that, as I say, I understand your position on that, but again, I strongly disagree with that. With respect to proposal number 5, that's the Form 6 for the municipal officials. Great idea, and the reason I think it's a great idea is because I brought it up to you guys several years ago. And right here in terms of that, because it wasn't on your list. And the reason I brought it up at that point in time is this. Believe it or not, notwithstanding all the harping and whining about people in small counties and or small cities that have to do this kind of thing, to accurately fill out a Form 1 is a more difficult task than filling out a Form 6. It truly is. And as I try to explain it to people, you have to understand math, and you have to do all this kind of math, and you have to do algebra to actually fill it out. Whereas with a Form 6, you just put on the information and let it rip. And that's what you do. The only math that's involved on a Form 6 is your secondary sources of income. And then again, most people don't have that as well that are in government. So anyway, those are my remarks, and I thank you for the time.
Thank you, Mr. Turner. Anyone have any questions?
I
Commissioner
have a
Berger?
question for you. Trying to understand your position on the attorney's fees. Is your position that the statutes and the case law as it is now is sufficient?
It is, Mr. Berger. The reason is that the case, the seminal case, which is the Brown case, talks about this being a high standard. It talks about you have to actually prove that there, and moving forward, you have to prove that 3 elements. One, there was lies in the complaint. The complaint was filed to maliciously attack the public official, and the allegations had to be material to the Ethics Commission's investigation, which is a case you guys won. And I appreciate that too, because it does limit the amount of attorney's fees petitions that you get.
And then the second question to you, because the position that was brought forward was about equaling or leveling the playing field. And then I had a question to that, which is how often do you see these attorney's fees situations occurring?
Well, again, I sit in these meetings for the most part, or watch you on the internet. They kind of come and go in waves. Sometimes there's a bunch. Sometimes you don't get any for a year or more. I know that public officials oftentimes get mad that complaints are filed against them, and when they win the complaint or they're dismissed of probable cause, they want to somehow maybe strike back at the complainant. But I can tell you that I always caution my clients in terms of that is I look at the complaint and I say we have to verify the lie and we have to establish the malice, and now we have to establish the materiality based on the complaint on that other case. So not many of these petitions go forward. And the other point that's involved in these cases, on the attorney's fees cases, and sometimes it's lost in the shuffle, and I don't know if every attorney does this or I do, but I always try to offer the complainant the opportunity to settle the matter up front before I file the petition. And the reason for doing that is that in some of these cases, the amount of attorney's fees expended in terms of responding to the complaint through probable cause stage is minuscule. Now, I know some attorneys come up with 5- and 6-figure claims to get that far, which to me is nonsense. But I've offered to settle some of these things for like $600, and they tell me to go to hell, and then we move forward. And then all of a sudden, it's not $600 anymore, it's $20,000, $50,000, or whatever. And again, it's because of that issue.
And then as far as you use the word gatekeeper, you refer to the legal analysis and then our decision and vote on whether or not it should get through as far as an attorney's fees case.
Well, Mr. Anderson, when he sat over there, as opposed to up there, was very good in terms of explaining why a petition was deficient in any particular case, and that's what I meant by the staff and this commission is the gatekeeper in terms of looking at the allegations and determining whether they are sufficient to move forward.
Commissioner Brady?
My remembrance is that the fee petitions that go through the administrative law judges have to come back to the commission.
Correct.
For approval. So in the event we felt something was horrendously poorly done, we can basically say no.
Well, yes and no, because you're bound by the APA, and whether there's evidence in there with respect to findings of fact, and so you're going to be a little bit constrained in that respect.
Any other questions of Mr. Herron? Thank you, Mr. Herron. Mr. Anderson?
Thank you. Appreciate those comments from Mr. Herron, and that brought up a couple of thoughts that I've had previously on just kind of practical thinking. I think there is a certain merit in leveling the playing field, and I think there have been some deterrence because of the attorney fee provision of people filing complaints. That uptick, though, I think is somewhat related to the big warnings that went on the form a few years ago. I think he is correct on that. But of course, underlying that is the ability of somebody to seek fees always that they have. Now it's just more advertised on the form. But if you look at the evolution or development, probably a better word, of the attorney fee statute over the years, the way that the legislature has treated it is it has been there to desire to make it more available for a respondent to succeed in getting fees. Now, it still is a pretty high standard, and we do weed out petitions that are inadequate on the front end. Frankly, though, having looked at the way legislation has been done on a number of parts of the code, I think it's worthy maybe to want to have the complainant be able to get fees, but honestly, I feel like that the legislature, having exhibited only a desire over many decades to make it easier for a respondent to get fees, I don't think they'd really be receptive to changing the law to let complainants get their fees. I think that if you're talking about economy of legislative effort, I don't think this would go anywhere, just to be brutally honest. And Ms. Stillman, you've been over there more than I have. Do you think any different on that?
Ms. Stillman?
This particular proposal has not gotten any traction. The discussion was there because I think we had a number of fees cases come through. And if somebody says, I didn't file this maliciously, and I'm going to defend myself, and I'm not going to settle, I'm going to defend myself at DOA on these allegations, and they ultimately prevail, they've probably had to hire an attorney in the process to defend themselves, and they won't be made whole. And so that was the idea behind it. Like I said, it hasn't gotten much traction in the legislature. There are certainly other arguments to be had, and it's at the commission's discretion whether you wish to make it a priority this year.
All right. I think maybe we go one by one of these items. So starting with the conflict of interest, does anyone have any strong for or against or changes that they would like to share with the commission? Yes, Commissioner Brady.
Would be there an issue in doing some of the wording recommendations that Mr. Herron made in terms of I guess, trying to make the language clearer? I mean, I thought this was fairly clear, but the people that are actually practitioners of the law may have a better sense than I do.
Through the chair.
Yes, sir.
Again, what you would need to decide today is this concept of closing this loophole. The exact wording that would do it, it could be what we wrote, it might be something that Mr. Herron suggested, it might be some other language, but I don't think the exact language is what you're voting on today. You'd just be voting that one of your legislative suggestions would be to close this loophole, and then ever how that might best be done. And we don't have any opposition to Mr. Herron and others making suggestions to the commission. We appreciate it.
I'd move to adopt the first, number one.
Second.
Okay. Motion by Commissioner Brady, second by Commissioner Lesnoff, just because I was looking at her and heard her first. Any further discussion on item number one? All in favor signify by saying aye.
Aye.
Aye. Any opposition by saying nay? All right, number one is a legislative.
If I might, and just for clarity, not to be redundant, but my understanding of that vote is that the commission is taking a position that they'd like to see that loophole closed, and they're authorizing staff to represent that commission, that position to the legislature and legislative staff, and be able to speak for bills and proposals to close that loophole and not just merely be informational speakers.
Yes, that's my understanding. That's what the vote was intended.
Yeah.
And all
Thank you.
these votes will be intended similarly.
Thank you.
Okay, number two, the attorney's fees provision. Does anyone want to speak on that matter for or against? Or comments? Mr. Berger.
The only comment would be is if we are going to get rid of one of them, it would be this one, based on hearing the economy of legislative effort. I mean, I don't have a druthers one way or the other. If we're prioritizing from 5 down to 4, this would be the one. We heard Mr. Herron's position on it, and we've heard from our executive director, and we've heard from Ms. Stillman about the traction or lack thereof that it's gotten. So I don't have any strong opinions one way or the other than if we're getting rid of one of them, this would be the one in my opinion.
And Mr. Brady?
Could we, move to adopt, but put it as the lowest priority item on the commission's list?
We could, but I've never been a fan of this position.
Oh, okay.
I agree with Mr. Herron. When I first got on this commission, we had 3 in my very first meeting, and there was a sense that the commission had generally voted against petitions, and I think that has changed a little bit. But I've always been struck by the malicious and intending to injure the reputation, and the fact that we are the gatekeeper to even allow that petition go forward. I think that the complaint, I've never liked this. I think it's not the intent of the way the ethics code or legislation or litigation in general should go. So, yes, I mean, you can move whatever you want. I won't be supporting this. I wasn't here for this discussion last year, but in past years, I've not been in favor of making these changes. So, my 3 cents. But Commissioner Brady, anyone else have any comments?
Move to item 3.
Oh, no, but you make a motion. I mean, you can move to adopt it?
No, it's
Okay.
fine.
Anyone? Commissioner Berger?
Again, I mean, there's good arguments both ways. I'm just gonna make the motion to not adopt and get down to 4 and prioritize based on the lack of traction that we've heard from.
Is there a second?
I'll second that.
Okay. Motion by Commissioner Berger, second by Commissioner Brady to not add this as a legislative issue for this year's legislative session, 2020. Any more comments, questions? All in favor of removing it from the legislative recommendations signify by saying aye. Aye. Any opposed to that motion signify by saying nay. That will be removed from the legislative recommendations. The next item is voting conflicts law. Is there discussion for or against? Commissioner Lesnar?
Yeah, and I'm of 2 minds about this issue. Certainly, I think it's one that has, I have little doubt, has been abused. I also think that it is possible that the separate standard exists, particularly at the legislature, because of the nature of a representative democracy, where you have the legislature is setting public policy, and you would expect that those representatives have expertise in certain areas, sometimes due to their current employment or their employment history. And that if you restrict that, you limit the ability for the legislature to do its effective work in the assignment of members to committees and chairmans and policies, et cetera. Having said all that, which I think is something legitimate to think about, the notion of human behavior going the wrong way is equally compelling, but I just wanted to raise that as a potential legitimate reason for that double standard to exist, and that is the broad nature of statewide policies that is put forth by the legislature.
Thank you. Any other comments? Is there a motion?
Move to adopt number 3.
Is there a second?
Second.
Any further discussion? All in favor of adopting number 3 as a recommendation for the 2020 legislative session signify by saying aye.
Aye.
Any opposed signify by saying nay. Okay, that is adopted as a legislative recommendation. Number 4, appearance before boards, that we would oppose any change to that standard. So any comments? Yes.
If I remember correctly, this issue does come up typically at the end of session. It, shows up as an amendment on the floor. If we vote to approve, does that also allow the commission to, on an impromptu basis, go downtown and say, we oppose this?
That's
I
the
believe
intent,
very
yeah.
strongly on, I've seen, I know this issue, and it's a significant one.
Is there a motion?
Move to adopt number
Second.
4.
Okay, a motion by Commissioner Brady, second by Commissioner Lesnoff. Is there any further discussion? All in favor of adding this position to our recommendation signify by saying aye.
Aye.
Any opposed signify by saying nay. Hearing none, motion passes. Number 5, enhanced financial disclosure for municipal officers. Discussion? Thoughts? Commissioner Brady?
I have had to resubmit Form 1X each of the last 3 years, because when we go through and get people that have issues in terms of financial disclosure, to really understand how complicated it is to take every single asset in your 401K and identify it on an attachment. I mean, I've looked at Form 6, and I do think it may be easier for people, and, you know, I understand the issues with Village of Miami Shores. My son is account commissioner. I think he gets $1 a year and not a free parking space. My sister is a commissioner in the city of Coral Gables, and she gets parking and health insurance and a lot of other stuff, that it's easier just to say there's going to be a single standard for elected officials and just go with that. Because I think by the time you get done with, you know, the city with 1,000 people who doesn't tax, and Miami-Dade County, you'll never get a standard that people can agree to beyond saying, hey, the elected official, do this. And I do think Form 6 is actually, in my experience, easier to do than Form 1.
Is that a motion, Commissioner
I
Brady?
move to adopt issue 5.
All right, well, let me get a motion, and is there a second?
Second.
All right, motion by Commissioner Brady, second by Commissioner Berger. Mr. Anderson would like to make a comment.
Thank you, Chair. Just on that, Commissioner Brady, in thinking about this, it's been like, you know, elected municipal officials and not like elected special district people. Like, you know, that's a whole different world, and it would be, you know, a whole lot more of elected officials, but it wouldn't be everybody that's elected, only if they're like municipal elected.
Any other comments, questions, discussion? Okay. All in favor of adding the enhanced financial disclosure as a legislative recommendation signify by saying aye.
Aye.
Any opposed by nay? Hearing none, that is added. All right, is there any sense that we want to prioritize these, or comments, discussion, or just leave them there for the staff and representative to do as it comes up? I mean, is there anything we really want to push? Is there anything that the commission feels very strongly about? I'm not hearing anything. All right, do we want to have someone local to act as a spokesperson, or allow Mr. Anderson to act as a spokesperson? How does the commission feel on that? Mr. Berger?
Just an opinion, what has been done in the past is Mr. Anderson has had someone to his, or I should say Berlindia had someone to assist her now, our executive director. So my personal opinion is someone local that we can address, and I don't like to volunteer people, but I am looking at Commissioner Meggs here. We do have someone here.
I have vowed never to enter the state capitol.
Mr. Carvajal's not here and may not be able to in his current position.
Yeah, I mean, I feel Jason's, you know, thing. I mean, if you're not here, it's really difficult for you, you know, besides calling people, and I did at one point in time do more of that stuff aggressively, and it's literally impossible to get anybody on the phone during the session. So I'm going to talk to Mr. Carval, see if he's willing to do it. I think any number of us would be willing to talk about this on a phone conference, to try to get some sense of what's going on, if there's anything. I think everybody would be willing to go to their local delegations and say, you know, on the Commission of Ethics, these are the Commission of Ethics recommendations. But I mean, short of being able to really do this and not be here is very, very, I think, difficult.
Okay, so,
Well, I would be willing to go with
Mr. Anderson?
over
Yes, Mr. Anderson.
Through the chair.
but he doesn't need.
No, that would be great, Commissioner Meggs, and I think if this could encompass, you know, Mr. Meggs being the contact person and the person on this, a committee of one, so to speak, and also if that could include Ms. Stillman in addition to myself, as being, you know,
certainly.
operatives for the commission.
Is there a consensus that our executive director and deputy director will work in concert with Mr. Meggs as needed, and then those of us will pitch in when we can. I think that's, I don't think we need a vote on that. I think that's just the operative way to do it based upon Mr. Meggs volunteering or being forced to volunteer. I'm not sure which. But thank you, Commissioner Meggs. Reluctantly. Is there anything else we want to add to this list? I apologize. I forgot that step. Okay, I see nothing. All right. Without anything else on our agenda, I'd ask for a motion to adjourn.
Reports.
Oh, reports, I'm sorry. No offense, sorry. I missed that.
Item 10.
Oh, that's right, I'm sorry. I have no report. Update on electronic financial,
I'm sorry, the consideration of financial.
oh, I'm sorry. I was so excited, I thought we were done. Consideration of expenditures, item 10, Mr. Anderson.
Thank you, Chair Rosanka. What that is the default authority that I have to commit money for the commission. I think it's $10,000, and we have a need to build out part of the office to make a cubicle into an enclosed space so that it'll be confidential enough and suitable enough for a new investigator that we really need to hire in view of a number of factors. And what this would be is if you approve this, then I'd be able to commit the money for, I think it's $14,781, and that's a relatively new quote we got from the fellow just a couple of 3 weeks ago that would be doing the build out, and that's all because it's in a complex and they got to use a certain person, and it's all the way it has to be, and we can't try to get a cheapy thing out there with a bid or something that's sort of locked in. But this new figure is not a whole lot different than what it was a year or so ago. But I need your approval, though, to be able to do that in view of the default limit being just $10,000.
Commissioner Brady?
Yeah, if it's more than 14,781, would you have to come back?
I thought about that too, through the chair. I thought about that too, what if it's another 50 cents? And
Let me make a motion to authorize the expenditure of up to $18,000 to carry the build-out, to authorize the executive director to spend up to $18,000 to complete the authorized build-out in your current office space.
Do I have a second?
Second.
I'm sorry, who was that? Commissioner, okay. Motion by Commissioner Brady, second by Commissioner Gilzine to approve an authorization of up to $18,000 for the executive director to complete the build-out. Any discussion? All in favor signify by saying aye. Aye. Any opposed signify by saying nay. No nays, the motion carries. Now on to reports. As chair, I have no report. I would move on to B, updated on electronic financial disclosure systems, I believe by Ms. Stillman.
Thank you, Madam Chair. I know everyone's ready to go, so I'll be as brief as possible. As most of you know, for the benefit of our new commissioner, the idea of electronic filing of financial disclosure in Florida has been an idea a long time coming. And I can remember back in the early 2000s, there was a study on it, never came to fruition. We were directed to do a report to the legislature in 2015, and then it got kind of quiet. And then last year, under the leadership of the House and the Senate, it was a priority of them to get it done. And so in conjunction with the ethics committees in the House and the Senate, our staff and their staffs worked really, really hard to follow that roadmap and put together a bill that did successfully pass both chambers and became law. Before it became law on July 1st, our staff was already meeting with the Office of Legislative Information Technology, which we lovingly refer to as OLITS. That's our in-house IT support for the Ethics Commission. We are teaming up with them on this project. It is a multi-million-dollar project, and so it requires a lot of expertise. It is complicated, and in an age where you can push a button and get something delivered to your house in 2 days, people think something like this is easy. There are lots and lots of moving parts. We had hoped, OLITS is doing staff augmentation to bring in some expertise to help with coding so that we can meet the deadlines. The Form 6s are the first ones that will be filed electronically. They had hoped to have a lot of that staff aug done by July 1st. It took a little bit longer. We have already heard from them that they've got a few people they put in place last week, which of course is later than what we had hoped, but Kim and Lynn have been spending a lot of time with the folks at Olitz, both in meetings at our office, on the phone every day, and even embedded down at Olitz to work to get these folks up to speed. So we are moving quickly, and we expect to achieve the goal of having this go live and making it smooth for all the Form 6 filers who will be required to file that form. And we are determined to make it a product that this commission will be proud to stand behind. And so we will periodically update you as to the progress that we are making on it and any issues that might arise. There may be some legislative tweaks that need to be done to the bill, and I've talked to the Senate. I haven't yet talked to the House, but I know they'll be behind helping us get this done.
Thank you. Mr. Anderson, Executive Director's report.
Thank you, Chair Rosanka. You have my written report there, and I have one thing to add to it. Of course, most or all of you are aware of all the effort at the last meeting to come up with rule language to be our part of the Constitutional Amendment 12 that created the abuse of public position standard. And I think we had a really good meeting. We came up with some really good language. And Mr. Schaefer has been heavily involved in all that, and I want to personally thank him for all his effort on that, as well as Ms. Clanky assisting on the rules, that one and others. So we're going through this, process under Chapter 120. We have to do certain things by certain dates, notice of change, all these kind of things, which we did. And then at 4:59 of the last day that somebody could file a rule challenge against our proposed rule, we did get a rule challenge filed at the Division of Administrative Hearings, which of course, had it not gone away, and the good news is that it did go away, it would have roadblocked the ability of our rule to take effect by October 1st, which is in the Constitution. It says we're supposed to do our rulemaking in regard to the constitutional amendment by October 1st. So the short story is that Mr. Schaefer and I negotiated with the attorney representing the two parties that or two entities that brought the challenge, and we achieved their dismissal of the rule challenge, and that was done in time that Mr. Schaefer was able to file the rule for adoption timely. And if you would, Gray, tell us what date the rule is going to go into effect.
I believe it will be effective on October 1st.
Wow. Yay.
But that is a little wrinkle that I thought y'all might want to know about that I didn't have a chance to write about.
All right, seeing nothing further on the agenda, do I have a motion to adjourn?
So moved.
Motion and second by Mr. Lesnoff. And all in favor say aye.
Aye.
Any opposed, say nay. All right, we are adjourned until 12:15, and please be prompt so we can move along.